Lordship, I'm appearing on behalf of the defendant, Lordship. This has come through an office report, my lord, because there was an issue with my wakalatnama. Lordship, this is an error on our part because when we had filed the wakalatnama, if you see, Lordship, the CS COM number is 232 of 2024, but this old CS number is 9 of 2021. However, in our wakalatnama, it was written 9 of 2020. So when we went to the department and filed it, Lordship, it was filed in the wrong CS. And there was no wakalatnama in that CS number. So when we filed the first wakalatnama, Lordship, it is written at the back side that writ of summons has been served on such and such date. Wakalatnama is within time or outside time. But in our suit, that was not the scenario. However, because it was going in the wrong record, it was there. So when we were asked to write that, we could not write that because it would have been a wrong statement. So that's the issue, Lordship. We'll have it rectified with the department. We have spoken to them already. It's my lord's direction for the office report, and that's why it's here before my lord. We have spoken to them and it can be rectified, Lordship.
What is the actual problem?
Lordship, the
You
problem is
want to
that
file a wakalatnam on old new one?
in the
CSCOM,
it has been renamed as CSCOM,
CSCOM, yes.
but the old number is 2021. But
No,
we have
not 20.
That is the error we have done, Lordship. That is the error we have done. The report which my lord has received, it is for CS 9 of 2020. But our suit number is 9 of 2021, Lordship. So I have to carry out the correction in my wakalatnama and I have to correct it from 2020.
So it is 2021.
Yes, Lordship.
So you want to correct the number.
Yes,
so
Lordship.
department is not allowing to correct.
Department never intimated us that we have did it wrong, Lordship. We missed it and department gave an office
Only
report
this one.
Yes, Lordship. And the erstwhile advocate on record will take no objection. She's
No,
here with me.
there's any rates of wakalatnama along with the affidavit of competency. It is submitted that the land advocate intend to enter appearance of the defendant after no objection from Fox and Mandal. But as per the suit registry maintained by the suit registry department, no advocate has entered appearance.
Because they are checking the record of CS 9 of 2020.
2021 they had appeared.
Yes, Lordship. 2021, the Miss Neha Datta is on record and she has entered appearance. Wakalatnama is there. A written statement is filed. The suit is at the evidence stage, Lordship. So there is no discrepancy in our main suit, but because it was being registered in the wrong diary, it was recorded wrongly.
The matter is listed as to be mentioned on receipt of the report from the office of the suit registry department of the original site. As per the report, the learned advocate, you file the wakalatnama on whose behalf?
Defendant, Lordship.
The learned advocate, what is the good name? Who has filed this wakalatnama?
Sanjay Ginodia, Lordship.
Learned advocate on record, namely Sanjay Ginodia, has filed wakalatnama in connection with old CS in connection with CS COM number 232 of 2024 within bracket old CS number 9 of 2020 on 4th of August 2025. 4th of August? You filed on 4th August?
Yes, Lordship.
4th August 2025. But and has also obtained no objection from Fox and Mandal, who has appeared for the defendant.
There is
earlier.
one error in this. I'm
Earlier.
sorry to interrupt, Lordship. The no objection has to be obtained not from Fox and Mandal, but from Miss Neha Datta, Lordship.
Fox and Mandal, advocate who had appeared for the defendant. In the report, it is mentioned that no advocate had appeared on behalf of the defendant. No advocate had appeared on behalf of the defendant. Full stop. Subpara. When the matter is called, learned advocate on record of the defendant. When the matter is called, learned advocate, what's the good name?
Mini Agarwal, Lordship. Mini Agarwal.
Learned advocate Mini Agarwal submits that. Though the case number, though CS COM number 232 of 2024 is corresponding to old CS number 9 of 2021, but inadvertently in the Wakalatnama as well as in the affidavit of competency, the old CS number has been wrongly entered as CS number 9 of 2020 instead of 9 of 2020. See, further submitted, the department has taken into consideration of the record of CS number 9 of 2020 and not the CS number, not consult with the record of CS 9 of 2021. She submitted as per record in CS 9 of 2021. Mr. who had appeared,
Miss Sneha Datta was the
Sneha Datta had filed Wakalatnama on behalf of the defendant. Now she is ready to give objection.
Yes, Lord. No
No
objection.
objection. 2. Mr. Sanjay Ginodia to file press Wakalatnama as well as affidavit of competency on behalf of the defendant.
Yes.
In view of the above, the defendant is the learned advocate, Mr. Sanjay Ginodia, is given liberty to correct the year of CS 9 of 2020 as CS 9 of 2021 in both Wakalatnama as well as in the affidavit of competency, and to obtain no objection from the earlier erstwhile advocate, Ms. Sneha Datta, and to file, and the department is directed to accept the said Wakalatnama within a week from date.
Grateful, my Lord. So grateful.
I'm appearing for the respondent number 11 bank.
Lord, I appear for the petitioner.
Yes.
My Lord, Mr. Banerjee will be here in 5 minutes. I'll start, my Lord, and there won't be any repetition.
Lord, we'll submit on the next day with your lordship's prayer.
Let they complete.
Yes.
My Lord.
Yes, madam.
This is taking a bit of time, but my Lord, so far as the BRH group companies and the present directors are concerned, my Lord, this is very authoritative because it's an opinion of an expert body. Now, so far as the past directors, my Lord, and the role of the banks and other financial institutions, my Lord, after this, my Lord, we'll have to take, my Lord, into the affidavits, my Lord, in the case of... My Lord, kindly takes up volume number 3.
Yes.
On the last day, my Lord, we had stopped at page number 390. My Lord, right before the non-maintenance of the register of pledge. My Lord, that's very important for our case. My Lord, at page 390, para 48 onwards.
Yes.
My Lord. Register of pledge not maintained and details of pledged shares of clients not provided by BRH CPL. My Lord, this is the response number 8. To ensure that client securities maintained with the stockbroker are reflected in the client DP account maintained by it, SEBI has put in place measures for periodic reconciliation of these two accounts. Towards this end, SEBI circular number such and such date of September 26, 2016 on advanced enhanced supervision provides as under. My Lord will remember their defense was 2019 was the first time this circular came and the entire procedure turned on its head. The stock exchange, this is the circular. The stock exchanges shall put in place a mechanism and ensure that stockbrokers upload the following data on a monthly basis for every client onto each stock exchange system where the broker is a member. So exchange-wise, end-of-day fund balance as per client ledger, consolidated across all segments, and also net funds payable or receivable by the broker to or from the client across all exchanges. End-of-day security balances as on the last trading day of the month, consolidated ISIN-wise, that is total number of ISINs and number of securities across all ISINs. For every client, number of securities pledged, if any, and the funds raised from the pledging of such securities. The data at para 7.1.1, 7.1.2, and 7.1.3 pertains to the last trading day of the month. The stockbroker shall submit the aforesaid data within 7 days of the last trading day of the month. will show, my lord, this practice has been continuing in this company since 2005.
Yes.
If every month they're supposed to share all this data and the regulatory bodies are supposed to keep a check on this, and I'll have to pay 49. It was noted during the inspection that as on March 28, 2018, as per the statements provided by BRHCPL, there were no securities in the client DP account maintained by it. Despite this, it was noted that BRHCPL had pledged and unpledged many shares during the period April 2017 to September 2018 from its DP account having client ID such and such. It is also noted from the records that during the inspection, BRHCPL was not able to provide the register of pledge and details of clients whose securities has been pledged by them along with purpose of such pledge. My lord has seen previously from respondent number 1 with whom I pledged my shares, from them to BRHCPL they have gone. Now BRHCPL have further pledged them, no details available.
Correct.
In view of the above, I hold that BRH, which is the respondent number 1, has failed to provide details of pledge of client securities, thus violated SEBI circular number such and such. Bounce email notification of electronic contract notes, my lord. This shall not be, my lord, this shall not be that relevant if my lord kindly comes to para number 53 at page 393 onwards. My lord, these are the ultimate findings and the fixation of liabilities. Having recorded my findings on the contraventions that have been alleged against notice numbers 1, 2, 7 and 11. The next issue that my lord will kindly see 1, 2, 7 and 11, my lord, are the respondent numbers 1, 8, 15 and the other one, which there are other group companies, my lord, who have also participated in this fraud. The next issue that arises for consideration is the liability of the directors, my lord, of the notice numbers 1 and 2 for the contraventions established in the preceding paragraphs. Notices 3 and 5, my lord, 3 and 5 are respondent number 2 and 3, my lord, in this present matter, where directors of both BRH and BRHCPL during the period covered under the forensic audit report. Notice 3, my lord, is Mr. Bhatter, respondent number 3, I note, apart from being a director in these two companies right from 2004, was also the promoter of both these entities. Notice 5 was appointed as a director in both these entities on August 24, 2018. Notice 4 was a director of notice number 1 from the year 2004 and notice 6 was a director of BRHCPL from the year 2016. I note that when violations of the magnitude that have been detailed in the preceding paragraphs of this order stand established against a company, then it becomes necessary to ensure that persons in charge of the company during the relevant period are held accountable. Directors are responsible for the day-to-day management of a company and have the duty to ensure that the company is complying with applicable regulatory norms. I therefore know that the directors in such cases cannot escape from the liability arising out of the contraventions by the company. In this regard, Section 27 of the SEBI Act, now, my lord. Kindly sees contravention by company, Section 27(1). I'm placing from here only, my lord, where a contravention of any of the provisions of this act or any rule, regulation, direction or order made thereunder has been committed by a company. Every person who at the time the contravention was committed was in charge of and responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the contravention and shall be liable to be proceeded against and punished accordingly. My lord, will come back to this when we are talking about the liabilities of the past directors, because this is very clear at the time the contravention was committed. So, provided that nothing contained in this subsection shall render any such person liable to any punishment provided in this act if he proves that the contravention was committed without his knowledge or that he had exercised due diligence to prevent the commission of such contravention. This is their effort, my lord, in fact, to prove. Notwithstanding anything contained in subsection 1, wherein contravention under this act has been committed by a company, and it is proved that the contravention has been committed with the consent or connivance of, or is attributable to any neglect on the part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall also be deemed to be guilty of the contravention and shall be liable to be proceeded against and punished accordingly. For the purposes of this section, company such and such. So, my lord, there are twofold liabilities. One is direct involvement in that act, and second is negligence also. And for the period when that actions are committed. Now, my lord, kindly comes to para 54. While addressing the question of the liability of the directors, I cannot lose sight of the fact that Notice 3 was not just a director of Notice 1 and 2 right from the year 2004. He also directly or indirectly held significant beneficial interest in both these companies. Notice 4, I note, was a director of the Notice number 1 from the year 2004 itself, and therefore cannot avoid liability merely by stating that even though he has been designated as a director, he continued to act as an employee and had received remuneration only commensurate to the said role. I note that the notice numbers 5 and 6 have also made similar arguments to the one made by the notice number 4. It is noted that Notice 6 was appointed as a director of Notice 2 with effect from 1st July 2016, and therefore it is noted that he acted as a director of Notice 2 for the entire period covered under the forensic audit report. Notice 5, on the other hand, I note, was appointed as a director of Notice 1 only with effect from 24th August 2018, and therefore acted in the role of a director of Notice 1 only for a period of 13 months out of more than 40 months covered under the FAR. Therefore, the liability of the said noticee will be limited to the time he spent as a director of noticee number 1. I shall now proceed to consider the directions that should be issued against notices that would be commensurate with the violations committed by them. A stockbroker plays a critical role in the securities market as it acts as an interface for retail investors and is therefore required to maintain high standards of integrity and fairness in the conduct of its business dealings and uphold the trust reposed by investors who hold their funds and securities with it. As a regulator of the capital markets, SEBI has a duty to safeguard the interest of investors and ensure that their rights are protected. Notices 1 and 2 have shown blatant disregard to applicable regulatory norms, which has resulted in not just losses being suffered by its clients, but has also shaken the faith reposed by average investor in the market institutions. I am therefore of the considered view that such actions on the part of a registered intermediary needs to be dealt with a stern hand to protect the integrity of the securities market. It is also noted that the show cause notice had also called upon the notices to show cause for not imposing penalties under Section 15HA of the SEBI Act for violation of provisions of Section 12 of the SEBI Act, read with Regulation 3D, 41, 42M, and 42P of, my lord, the prohibition of fraudulent and unfair trade practice related to security market regulations, which are alleged to have been attracted on account of their role in misappropriating or misutilizing funds and securities of the clients of notices numbers 1 and 2. Before proceeding to consider this issue, it would be appropriate to reproduce the said provisions which have been alleged to have been attracted by the noticee. Regulation number 3, my lord, of the PFUTP regulations, prohibition of certain dealings in securities. No person shall directly or indirectly engage in any act, practice, course of business which operates or would operate as fraud or deceit upon any person in connection with any dealing or in issue of securities which are listed or proposed to be listed on a recognized stock exchange in contravention of the provisions of the Act or the rules and regulations made thereunder. Regulation 4, prohibition of manipulative, fraudulent, and unfair trade practices. Without prejudice to the provisions of Regulation 3, no person shall indulge in a manipulative, fraudulent, or an unfair trade practice in securities markets. For the removal of doubts, it is clarified that any act of diversion, misutilization, or siphoning off of assets or earnings of a company whose securities are listed or any concealment of such act or device, scheme or artifice to manipulate the books of accounts or financial statement of such a company that would directly or indirectly manipulate the price of securities, that company shall be and shall always be deemed to have been considered as manipulative, fraudulent, and an unfair trade practice in the securities market. Dealing in securities shall be deemed to be a manipulative, fraudulent, or an unfair trade practice if it involves any of the following. My lord, now M, my lord, they have set out only two, the relevant ones. M, a market participant entering into transactions on behalf of client without the knowledge of or instruction from client, or misutilizing or diverting the funds and securities of the client held in fiduciary capacity, which is exactly the case in the present matter. An intermediary predating or otherwise falsifying records, including contract notes, client's instructions, balance of security statements, client account statements. Para 57, as already stated in the preceding part of this order, notices 1 and 2 have violated provisions of the SEBI circulars by misappropriating client funds and securities and diverting funds to related entities. Notice numbers 6 to 11. Well, some of them are respondents in the present matter. The said related entities, that is notice number 6 to 11, have also played a major role in aiding and abetting BRH and BRH CPL, respond numbers 1 and 8, in misappropriating the securities and funds of their client. Further, the noticee number 3 to 6 were the directors of notices 1 and 2 during the period when the misutilization of funds and securities was happening. In view of the same, I hold that the said actions of the notices fall within the definition of fraud as defined under Regulation 21C of the PFUTP regulations, and thereby attract the provisions of Section 12A of the SEBI Act, read with Regulation 2D and 4.1 of the PFUTP regulations. Further, such actions also attract the provisions of Regulations 4.2M from February 1, 2019 till the date of the interim order. I also note the instant proceedings also provide for imposing of monetary penalty under Section 15HA of the SEBI Act and 23D of the Securities Contract Regulation Act. Relevant penalty provisions are reproduced herein below. Well, I'll skip those
Not
parts because
required
those
to
are under the SEBI Act. Now, kindly comes to para 59,
Yes.
page 398. Upon consideration of the penalty provisions, I find that notices 1 and 2, by failing to segregate securities funds of its clients and diverting such securities and funds to third parties, has failed in performing its statutory and fiduciary obligations, and therefore make them liable for imposition of monetary penalty under Section 23D of the SCRA. Further, as stated above, the conduct of the notices fall within the definition of fraud under the PFUTP regulations, and therefore notices 1 to 3 and 7 to 11 are also liable for monetary penalties under Section 15HA of the SEBI Act. On the question of monetary penalty to be imposed on noticing number 4 to 6, I note that they have already undergone debarment pursuant to interim order for a period of more than 3 years. I cannot also lose sight of the fact that noticing number 3 was managing the affairs of notices 1 and 2, which is also borne out in the settlement agreement dated 1st September 2018 entered into between noticing number 3, Avinash Agarwala and others. In view of the same, I am of the considered view that no further directions or penalty are required against them. Now, my lord, the directions are given. My lord, kindly sees in view of the foregoing, I, in exercise of the powers conferred upon me under section such and such, read with Section 19 of the SEBI Act and Section 12A of the Securities Contract Regulation Act, pass the following directions. Notices number 1 to 3 are hereby restrained from accessing the securities market and prohibited from buying, selling, or otherwise dealing in securities or being associated with securities market for a period of 7 years. 7 to 11, again, my lord, similar manner, restricted from accessing the securities market for 5 years. For clarified that the period of restraint already undergone pursuant to the interim order, read with the confirmatory order, shall be taken into consideration and set off. Now, my lord, monetary penalty, my lord, kindly sees, is imposed in clause D, my lord. Notice number 1, that is the respond number 1, 5 crore. Respond number 8, again 5 crore. Notice number 3, the director, one of the 2 promoter directors of the company, my lord. Notice number 3, 1 crore. And then 10 lakhs each to the other notices. Directions issued in the interim order shall stand vacated. Notices number 1, 2, and 3 shall jointly and severally be liable to repay, refund the monies due to the investors, clients of notice number 1 under the supervision of the National Stock Exchange. Notices 1, 2, and 3 shall jointly and severally be liable to return the securities due to the investors' claims of notice number 1 or their monetary value as on the date of actual payment of money in lieu of shares. They shall not dispose of or alienate any of the assets, including funds in their bank accounts. No debits are made in the bank accounts, my lord. Then my lord kindly turns over to page number 401.
Yes.
My lord kindly comes to clause number L. The modalities of selling the assets, depositing the process thereof in the escrow accounts opened in accordance with the directions contained in paragraph number J to K above, and disbursing the amounts to the client's investors after verifying the claim shall be worked out by NSE. NSE shall have a lien on the remaining account, if any, lying on the escrow accounts. After satisfying the claims of the investors' clients, the lien shall be up to the extent of total money disbursed by the exchange out of the investor protection fund account.
Yes.
My lord, for this order, my lord, I'll stop here. Just that 2-3 pages had been missed out on the last occasion, my lord. That's important because the relation between the other this 1 and 2 and the other companies, my lord, is spelled out. My lord will kindly, if my lord kindly takes up page number 375.
Yes.
375. My lord will kindly come to para 17, my lord. My lord, right before that, my lord, SEBI had listed out what are the differences in monies that were found in records of all these related parties where this money had been siphoned.
Yes.
Now, my lord, SEBI in 17, in the last line, my lord, all these entities are connected to BRH, the details of which are given in the table here and below. My lord, this was perhaps missed out, my lord, when my learned senior was placing this. Kindly turns to page 376. A chart has been given, my lord.
Yes.
Now, my lord kindly sees first one is Prosperous Vyapar Private Limited. My lord, this company is the respond number 15.
Yes.
Now, my lord kindly sees the basis of connection which SEBI has found. This related party, it has received a loan against securities of rupees 5 crore. Devi Prasad Ganguly and Uma Bhaduri, who were directors of the company, were employees of BRH. Payments made to them, such as advance against salary, reimbursement of traveling expenses, etc., were observed in the books of the notice number 1. So BRH is having their employees are made directors of Prosperous, and their traveling expenses, reimbursement of salary, all this is being made, my lord. That's the siphoning off. The second one, my lord, Polo Setco tie-up, my lord. Kindly sees Polo Setco is the respondent number 16. 16. This was important, my lord, to establish the connection between the companies.
Yes.
Respondent number 16, my lord, Polo Setco tie-up.
Yes.
The second entity received loan against securities of rupees 80.61 crores. Holds 26.06% shares in notices number 1 and 49% shares in notice number 2.
Yes.
Ramkishore Sharma and Vinay Dujari, who were directors of the company, were employees of BRH. Payments made to them, such as advance against salary, reimbursement of traveling expense, etc., were observed in the books of notice number 1.
Yes.
Third one, my lord, Parton Commercial Private Limited, respond number 17. 17, my lord.
Yes.
Received loan against securities of rupees 50.67 crores. Holds 0.08% shares in notice number 1. Vinay Dujari and Netre Thapa, who were of the directors of the company, who were the employees of BRH. Payments made to them, such as advance against salary, reimbursement of traveling expense, etc., were observed in the books of the notice number 1.
Yes.
AB Investment and Blue Snow, my lord, they are not parties to this particular suit, my lord. However, my lord will kindly also notice what they have done. AB Investment received loan against securities of rupees 1.8 crore. Related party of notice number 1, as disclosed by notice number 1 in its audited financials for FY 17 to 18. Blue Snow Supplier Private Limited. Ramkishore Sharma, who was one of the directors of the company, was
Blue is also not a party here.
No, both of them, my lord, they are not parties.
Yes.
Ramkishore Sharma, who was, however, my lord, this Ramkishore Sharma is also a director in Polo Setco, which
Yes.
is a party. So these are all interconnected, my lord. Ramkishore Sharma, who was one of the directors of the company, was an employee of the notice number 1. He was also a director of the notice number 8. Payments made to them, such as advance against salary, reimbursement of traveling expense, etc., were observed in the notice number, in the books of the notice number 1. Now, my lord, kindly sees para 18. In their replies, BRH and BRH-CPL first adopted the defense that the practice of pledging client shares was a standard industry practice and it enjoyed the implicit approval of the clients. I am, however, unable to accept this contention as it is noted the SEBI has put in place stringent norms. My lord, then all the regulations, my lord, all that is placed. So, my lord, kindly will turn over to page number 378.
Yes.
Now, my lord has already seen when the SEBI finds that anybody who was a director during the relevant point of time has to be gone. Yes. Now, kindly sees 22 and 23.
That I already pointed out.
Oh, no, okay, my lord. So, my lord, this I'll stop with. Then, my lord will kindly, I'll go take my lord straight into the affidavit on opposition, my lord, of the respondent number 5 and 6, who are the past directors, my lord. By the SEBI order, they had been let go. My lord kindly takes up the affidavits of respondent numbers 5 and 6. They are in peri materia, but if my lord takes up that one, that of 5, my lord, that would cover. Yeah. Yeah, সেটাই ভয় affirmed by Avinash Agarwala on 6th May 2025.
Affidavit of
Mr. Avinash Agarwala, my lord, the respondent number 5.
Yes.
My lord, I'll skip over the first formal paragraphs. My lord kindly comes to para number 11, where he sets out his case. Para 11 at page 14, my lord.
Yes.
I'm placing from para 11, subpara A. I'm not a director, shareholder, or promoter of the respondent number 1 company as on date and have no relationship with the said company. Even previously, my lord, that's his case, I was never involved in the day-to-day management of the respondent number 1 and was never in charge of the conduct of the business or operations of the respondent number 1. I have been and continue to be engaged in the business and manufacture of steel. I have no experience in the securities market or in the business of securities broking carried on by the respondent number 1 and was therefore never been actively involved in the stockbroking business. My role in the respondent number 1 company was extremely limited and was principally that of an investor who had invested money or capital in the respondent number 1. I resigned as a director of the respondent number 1 in 2018. In 2018, the respondent numbers 5, 6 and all their affiliates also sold all their shareholding in the respondent number 1 company and completely exited from the company and ceased to have any link with it. So, my lord, his cases 2018 onwards, 5 and 6, the two past directors and all their affiliates. But then my lord has seen in the SEBI order how their connected companies, my lord, are still part of this. From inception of the respondent number 1 and all throughout, the entire transactions, business and operations of the respondent number 1 were handled by the respondent number 3 and were under the sole and direct supervision and management and control of the respondent number 3. The respondent number 1's management team, including the respondent number 2 and the respondent number 7, etc., were accustomed to acting on the instructions of the respondent number 3 and reported to him alone. As per the records of the respondent number 13 NSE, the respondent numbers 2 and 3 were the designated directors of the respondent number 1 and were responsible for the management and affairs. The respondent number 3 always interacted with clients, associates, banks, and statutory authorities on behalf of the respondent number 1, passing the entire buck on the respondent number 3. My role was strictly limited and restricted to that of a financial investor who had invested money in the respondent number 1. I was never a designated director of the respondent number 1 company. I resigned as a director of the respondent number 1 on 17 September 2018, as would be evident from the records of the respondent number 13. Copies of Form DIR 12, my lord, there annexed. Now, my lord kindly turns over to para D. The designated directors of respondent number 1 were respondent number 3 and respondent number 2. And hence, it is those persons who would be responsible for the operations and management of the respondent number 1, including maintaining the respondent number 1's client documents, transaction records, pledging or transfer of client securities. Now, my lord, this stress on designated directors, that's only for the records of NSE. One second, Shiv Kumar Damani came in much later. In the beginning, when this practice was started, my lord, I'll show from the records.
Who is appearing for the 5?
5 and 6.
And who is appearing for 3? 2 and 3?
3, my lord, is being represented by Mr. Chaudhary.
I think because he has filed a common
With
opposition.
1,
3?
1, 3, 4 and 8.
1, 3, 4 and 8.
There is
my
one
lord.
common
All of
opposition.
them.
I think Mr. Jishnu Chaudhary is there.
They're still the directors of the company, so they're all being represented by Mr. Chaudhary. My lord kindly sees a copy of a letter issued by the respondent number 13 NSE showing that designated directors of the respondent number 1 were the respondent number 3 and the respondent number 2. And that respondent number 5 was only a non-designated director. I'll take my lord to the letter. It does not say anything about a non-designated director. It's only for the record says these two are the designated directors because they are involved in all the correspondences. That's it. In fact, my lord will kindly look into it right now while we are at it. My lord.
Where is Annexure B?
It is Annexure
B. Page
B, my lord,
55.
at page 55.
What is his name?
My lord,
Avinash
Agarwala. This letter is issued after he has resigned. So he goes off from the records and Shiv Kumar Damani and Anubhav Bhatta, they are the designated directors at this point of time. My lord kindly sees this letter is dated 17th of December 2018. He resigned in September 2018. Mr. Avinash Agarwala.
17 September 2008.
My lord.
Prospective.
This is with reference to the intimation regarding change in directors of the corporation, of the corporate trading member.
Yes.
Please note that the fee clearance for change in non-designated director in accordance with SEBI circular number such and such has been granted by the exchange to BMA Wealth Creators for changes in the director. This letter only records the change in directorship. This is what they're relying on to say, I was a non-designated director and these two were designated director. As on 17 December 2018, it's nobody's the case that he was a director in any capacity.
Yes. Yes.
Now, my lord kindly comes back to para D at page 16.
Yes.
After Annexure B, my lord, I never directly interacted or dealt with banks, statutory authorities, or clients or associates on behalf of the respondent number 1 and had no knowledge of the transactions conducted between the respondent number 1 and its bankers, clients, or associates. I do not personally know any of the petitioners, and to the best of my knowledge, I have never met or interacted with or had business dealings with any of the petitioners. I never indulged or started or otherwise approved of any practice of unauthorized pledging of client securities. I was never an active director of the respondent number 1, nor was I actively involved in the business of the respondent number 1. Kindly turns over the page. Various disputes having arisen between the respondent number 5, the respondent number 6, and their affiliates on the one hand, and the respondent number 3 and his affiliates, including the respondent number 15, 16, and 17 on the other. My affiliates and I completely exited from the respondent number 1 as shareholders with effect from 17 September 2018, despite suffering financial loss in the process. Such fact was also made known to the respondent number 13. The fact that the 13 is NSE, my lord. The fact that the shareholding of my affiliates and me in respondent number 1 had been reduced to nil with effect from 17th September 2018 was also taken on record by the respondent number 13 NSE. My lord, I'll show even after this period, he continued to remain the authorized signatory of the company.
Yes.
I am engaged full-time in the business of manufacturing steel. The company is managed by me and or the other descendants of my late great-grandfather, Mr. Bhuramal Agarwala, are known collectively as the BMA Group. Even within the BMA group of companies, different branches of the family of the late Bhuramal Agarwala manage their respective businesses independently. And hence, I am not involved in the management of several other companies within the BMA group itself. The respondent numbers 1, 3, and 8 are not members or part of the BMA group. At the time that the respondent numbers 5 and 6 and their affiliates were associated with the associated as shareholders or investors in the respondent number 1, the respondent number 3, kindly notes, 3 had been permitted to use the name BMA in the name of respondent numbers 1 and 8 for limited purpose only. So what my lord sees today as BRH Wealth Creators and BRH Wealth Commodities, those are actually part of this BMA group. However, after the exit of the respondent numbers 5 and 6 and their affiliates, use of the name BMA by the respondent numbers 1 and 8 were no longer permitted. Respondent number 5 has also issued a notice dated 14th August 2019 to the respondent number 1 and 8 in this regard. This is a notice which says do not use my name any further. Around this time, the respondent number 1, which was under the control of the respondent number 3, changed its name from BMA Wealth Creators Limited to BRH Wealth Creators Limited. Certificate of Incorporation annexed. Respondent numbers 15, 16, and 17 have never been part of or had any connection with the BMA group. The respondent numbers 5 and 6 and their affiliates have never had any association with 15, 16, and 17 and have never been shareholders, promoters, directors, or employees of respondent numbers 15, 16, and 17. Hence, it is completely false and untrue to suggest that respondent numbers 5, 6 or their affiliates control respondent numbers 15, 16, 17 or the respondent numbers 15, 16, and 17 are part of the BMA group. My lord has seen the connections already in the SEBI order. In July 2019, I learned that my signatures had been forged on personal guarantees and other documents submitted to the respondent number 11 by the respondent number 1 to obtain loans. In fact, some of the documents had been purported signed on dates when I was not even present in the country, as evident from my passport. This was immediately brought to the attention of the authorities, including the respondent number 1. However, my lord, kindly note, relevant documents not annexed. Crave leave. We do not know what he is basing all these claims on. Sometime or about March 2020, the respondent number 13 approached me, this is NSE, and sought for information in relation to respondent number 1 and his affairs. It is only then that I came to learn for the first time that SEBI was investigating the affairs of respondent number 1, and upon making further inquiries, came to learn that in September 2019, the respondent number 1 apparently defaulted on its obligations towards respondent number 13 and was suspended as a broker member. Thereafter, on 7th October 2019, the respondent number 12 passed an interim order, which inter alia states that SEBI had noted various irregularities at BRH Wealth Creators, including inter alia that certain securities had been misappropriated through 3 entities related to the respondent number 3, namely respondent number 15, 16, and 17. By such interim orders, SEBI froze the assets of respondent numbers 1, 2, 3, 7, 8, 15, 16, and 17, and also ordered a forensic audit. This order was based on a report submitted by respondent number 13 regarding the respondent number 1. And he turns over the page. It is pertinent that interim order dated 7th October 29 does not disclose or ascribe any involvement by the respondent numbers 5 or 6 or their affiliates in the wrongdoings in the business of the respondent number 1. No order was passed against the respondent numbers 5 and 6 or their affiliates, and no blame or liability of any sort was attached or attributed to them. It is evident from the said interim order dated 7th October 2019 that I had resigned as a director of the respondent number 1 prior to the violations noted therein, and that during the time when the alleged violations occurred, I was not a promoter or shareholder or director of the respondent number 1. I'll show my law this is absolutely untrue. Since 2005, this practice is going on according to HDFC's affidavit in opposition. On 2nd January 2020, after
The report which period to which period?
my lord, the
Which
report
period it was considered?
covers, my lord, I'll just indicate.
Misutilization Clients Fund VRH CPS 2017.
Circular. My lord, kindly give me one. এটা হচ্ছে my lord, this is from 1st April 2016 to 30th September 2019.
From 16 onwards.
From 16 onwards. However, my lord, it's an established fact along with documents. 2005, this has been going on. This is not done.
Yes.
My lord, kindly comes to subpara 4. On 2nd January 2020, after seeing the replies of the notices and giving a personal hearing, SEBI issued a confirmatory order which confirmed its earlier order. In the confirmatory order dated 2nd January 2020, the respondent number 12 noted that during oral hearing, my lord kindly sees the respondent number 3 had made certain allegations qua the respondent numbers 5 and 6, which are absolutely false and are denied by me. And accordingly, the respondent number 12 directed the forensic auditor appointed by the respondent number 13 to also look into the role of the respondent number 5 and 6, if any, in the unauthorized pledging or misappropriation of securities of respondent number 1 clients. It is pertinent to note that such direction was premised entirely on the oral submission made on behalf of the respondent number 3 and not on any material forming part of the report or inquiry by the respondent numbers 13 or 12. The said confirmatory order dated 2nd January 2020 does not disclose any evidence of wrongdoing or involvement of the respondent numbers 5, 6 or their affiliates. It is notable that even in January 2020, after the forensic audit in the affairs of the respondent number 1 had progressed considerably, neither respondent numbers 12 or 13 had found any ground to make the respondent numbers 5 or 6 parties to the proceeding or found any requirement of issuing directions against them. That, my lord, in my humble submission is against the SEBI Act itself, because during the commencement of all this irregularities, my lord, they were the persons who were in charge of the company. In compliance with SEBI's order dated 2nd January 2020, the respondent number 13 investigated the role of the respondent numbers 5 and 6 and sought certain explanations from the respondent numbers 5 and 6. I duly gave the explanations which were sought of me by the respondent number 13. On being satisfied with the explanations and information provided by me, respondent numbers 12 and 13 decided not to take steps against me in connection with the affairs of the respondent number 1. It is pertinent that the forensic audit itself noted the following facts. Surprising, we have been seeking a copy of this forensic audit report for a long time, my lord. In fact, we have also filed an application here that this forensic audit report be disclosed, because, my lord, according to NSE's affidavit, this maps all the securities. So at least for the period covered under it, my lord, we'll get to know where exactly everything lies. This forensic audit report, my lord, has been disclosed by NSE in a suit filed by some of the other investors before the Bombay High Court. However, my lord, here I do not understand why they're shying away. In compliance with SEBI's order dated 2nd January 2020, the response number 13 investigated let I place this. Now, my lord, kindly comes to para L. It is pertinent that the forensic audit itself noted the following facts: that the signatures on the certain bank documents purported to have been my signatures do not match the sample of my signatures, confirming my fear and belief that my signatures have been forged, and that during the period of FY 16-17 to 18-19, 3 companies affiliated with the response number 5 and 6 had paid a net amount of approximately rupees 54.66 crores to the response numbers 1 and 8. Around this time, a writ petition being number SCA number 493 of 2020, which was filed by some of the clients of response number 1 before the Honorable High Court at Gujarat. In the said writ petition, the petitioners therein had purported to challenge the alleged inaction on the part of the response number 12, qua the response number 5 and 6 herein, and had sought for directions to be issued to SEBI in this regard. The response numbers 5 and 6 herein were arrayed as the response numbers 5 and 8 in the said writ petition. Following reliefs are sought, my lord, I'll skip that over. Now, my lord, kindly comes to para N. In the said writ petition, the response number 12 herein had filed an affidavit dated 10th August 2021, whereas the response number 12 has inter alia stated as follows. In this regard, the forensic audit was conducted by the response number 3. The respondent is informed that the documents made available to the response number 3 in the course of forensic audit and submission made by erstwhile directors of the response number 4, the response number 3 did not find any evidence of involvement of the response number 5 and 8 in authorized pledging or misappropriation of client securities of the response number 4. As the response number 3 did not find any evidence of involvement of the response number 5 and response number 8 in unauthorized pledging or misappropriation of client securities of response number 4, it has been decided that no further enforcement action from this answering respondent against response number 5 and 8 is necessary. That is exactly what SEBI has said in that order itself, my lord. We do not find anything. However, the forensic audit report is not disclosed. Kindly comes to para O. No orders of any kind were passed against the response number 5 and 6, and the writ petition was thereafter disposed of by an order dated 29 June 2022. My lord, I'll place this order. It's a part of my affidavit in reply. This simply says, because disputed questions of fact are raised, this matter cannot be decided in a writ petition. It is not that they will let go scot-free specifically. In P, my lord, on 11 January 2023, the response number 12 issued the final order in the investigation relating to the conduct of the response number 1 inter alia under section such and such. The said order inter alia notes that allegations were purported to be made against the response numbers 5 and 6 herein, but that based on examination of the material available on record, it was decided not to proceed against 5 and 6. And accordingly, I was not made a notice in the proceeding before the response number 12. Directions were thereafter passed against the notices therein, but not against the response number 5 and 6. In the said order dated 11 January 2023, it has been held that it has specifically also been noted inter alia that the actions of the notices fall within the definition of fraud as defined under Regulation 21C of the Unfair Trade Practice Regulations, my lord, and thereby attract the provisions of Section 12A of the SEBI Act, read with Regulation 3D and 41 of the PFUTP regulations. Accordingly, appropriate penalties were levied against the said notices. Notably, no such finding was arrived at against the response numbers 5 and 6, since they were not found to be involved in the impugned acts after the full completion of the investigative process. Fraudulent, manipulative, and unfair trade practices in relation to SEBI markets, my lord, are governed by SEBI rules empowered by statute. This I'll skip over, my lord. No appeal has been found. This undertaken.
So he has taken the plea that he has not been involved.
He has not. He was one of the promoter directors.
Correct.
He says from the very beginning he has not been involved. He was not. He did not know about
Resigned
day-to-day
on
affairs.
September 7, 18.
And the name BMA, my lord, it was a part of their group. The respondent number 3 was allowed to use this name, and after the severe
Correct.
ties with the respondent number 3, that name was changed.
Yes.
Now, my lord will kindly from this AO, my lord, that is rest are denials and repetitions, my lord.
So these are the case he has made out till
That's all that he says. Yes. And the fact that SEBI has held that there is
He is
no
not responsible.
material available against him. My lord, respondent number 6 has also
Same.
given more or less a similar answer. Now, my lord, if only I can place that order of the Gujarat High Court that I just referred to show that 5 and 6, in fact, there is no order of any judicial forum that says that 5 and 6 should be let go scot-free. My lord kindly takes up my affidavit in reply. This is affidavit in reply affirmed by Madhav Prakash Mohta in May 2025. The date is missing. Reply to my file.
yes.
My lord is annexure B to my reply at page 77.
77.
Page 77, my lord. Affirmed by Madhav Prakash Mohta. My lord, this is a part of reply. One date tak nahi. May 2025. Sometime May
Against
2025.
against which affidavit?
That's one number 5's affidavit, my lord.
Question number 5. It's 18.
Affidavit in reply 14th May था. অনেক হ্যাঁ একসাথে অনেকগুলো করে অ্যাফার্ম হয়েছে না
चार का देखो ना 5 का एफिडेविट इन रिप्लाई ऑफ 5 5 का
আমার দেশে বাড়ি আছে আমি কলেজে যাচ্ছি আমার ইউনিয়ন
yes 77
Hello, kindly see, this is the order that the respondent number 5 was placing reliance on to say that nothing has been passed against him. My lord, kindly see, this is of the Gujarat High Court. Now, I'll take my lord right into the operative portion, my lord. Kindly see page 80. This, my lord, was filed by certain investors of respondent number 1, challenging the portion of the SEBI's order by which 5 and 6 were let go without any liability on that part. Kindly comes to 80. It is not in dispute that there are various disputed, para 8, my lord.
Yes.
Various disputed questions of fact involved in the repetition which can only be examined by the appellate tribunal. They're aggrieved by the inaction which are taken against other directors, excluded 5 to 8. And my lord, in view of the aforesaid disputed questions of fact, they can avail the remedy under the tribunal, my lord. So they're let go in view of the disputed questions of fact.
Yes.
That's all, my lord, from here. If my lord will kindly, so my lord, we have covered the present the companies, the related parties, and the present directors, and the past director, my lord. Now, what remains, my lord, are the banks and the financial institutions and their role in perpetuating the fraud. The fact that they have taken all this securities in pledge without due diligence on their part as to who the owner of this securities are. My lord, for that, my lord, the main chunk of all the securities have gone to the respondent number 11. Apart from the respondent number 11, respondent numbers 9 and 10 also have got quite a few share. According to the affidavits, my lord, the respondent numbers 9 and 10, JM Financial and Bajaj, my lord, both of them have already sold off the securities that were pledged with them. They say that we have nothing more to do.
when
Yeah.
it was sold after the order report
My lord, from their report, my lord, from their affidavit, my lord, I'll just place. My lord kindly takes up the affidavit of respondent number 9. 9 opposition director. This is an affidavit in opposition of Kunal Kothari. Date missing. I don't. Yes, one number 9, Mr. Kunal Kothari.
Yes. JM Finance.
GM Financial. My lord kindly first few paras I'll skip over, and my lord kindly comes to para 4 at page 10.
Yes.
Para 4A. The answering respondent is a systematically important non-deposit taking, non-banking financial company registered with the RBI and is engaged inter alia in the business of offering diversified loan services and ancillary facilities to various corporate entities, small to medium enterprises and individuals. Respondent number 9 has at all material times conducted its business and operations in accordance and compliance with all applicable laws, regulations, instructions framed and issued such and such. Now, my lord kindly sees. On 5th April 2016, respondent number 5 was still a director, my lord, 5th April 2016. BMA Wealth Creators Limited, the predecessor in interest of the respondent number 1, signed a loan application and a master loan agreement with the answering respondent for loan against securities. The initial demand loan facility was for rupees 100 crores on such terms and conditions as would be more fully evident from inter alia, the schedule of terms to the aforesaid master loan agreement. Now, my lord, this document is annexed.
How much time you will take further?
My lord, this would take another day, I think. My lord,
Only for one reason.
I'm at 9. That one
The
for 9th
affidavit?
affidavit.
After the affidavits are through, only 2 affidavits of moment. The others contain the same alibis as that are in the show cause notice. So those affidavits I'll just indicate point wise, give your lordship a note, that will be enough. But 2 things are important things which will be argued, I am sure. One is to how far can the court at this stage stretch the corporate veil doctrine, lifting of corporate veil? How far can you pierce? If an apparent fraud is also in front of you, how far can the court go? If everyone says, if 4 and 5 says we are not connected with the office, we were directors at one point of time, etc. Today, how far the liability can trickle back? There's material record to show that the purported continuing negligence continues from a point of time when they were on the board. So, though now not only judge made law to show your lordships that actually the needle can stretch that far.
9, 10 and 11.
9, 10 and 11's affidavits will also be required to be shown, but very briefly only for the purpose of the defenses. I'll need just one more day. I'll finish.
Yes.
I'm so sorry, my lord, that so many defendants had to file affidavits. Otherwise,
he has made so many person parties, so obviously
can't help it, my lord.
so nothing can be helped.
I wish Order 1, Rule 10 was differently worded, but what can be
That
done?
is no, but that is not in our hand.
I
didn't expect to Yes.
Parties का
In
नाम
fact, we thought
parties का नाम याद करिए. Counsel for the plaintiff has asked the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 20th August.
20.
20 August. 2020.
Okay.
The interim order expired.
Interim order is extended till 25th of August 2025 or until further order, whichever is sent.
Obliged.
Interim order till 20th.
25th.
আমি ভাবছি flight উঠে গেছে।
My lord, I appear for respondent number 12, my lord, virtually. My lord. Great.
My application, madam.
Please, Your Lordship. I'm appearing for the respondent.
Yes.
That we have an application which we filed, my lord, before my learned friend's application is taken up. May I
What
request
is
Your
your
Lordship?
application? Your application J1.
G4.
GA1 is my application.
One is my learned friend's application.
Uh-huh.
G4 is where, my lord, it's an innocuous prayer. And
GA4 I will not take. GA4 I will release.
I
Because
indicate why GA4
because
is required.
why I am telling, either the court has not gone into the order. This court has only fixed the part head with regard to GA1, not GA4.
I'll indicate why, my lord. The difficulty was, my lord, unless GA4 is heard, but GA1 is an interim, it's an application for, my lord, injunction.
Injunction. It was for injunction, madam.
GA4 is where we have prayed, and GA4 is a, my lord, filed by abundant caution. The reason is, here we have prayed that let a special general meeting be convened by us for the members. It's a club, my lord. At the end of the day, what's happened is this individual, there are a lot of allegations against the individual. And, my lord, at the time of election, he comes up before the court, and, my lord, we had given him a time that you have to withdraw all the pending cases that you have filed, which he said we will. He faltered, given them a chance. He doesn't do it. Then we gave a letter that since this is the case, we are terminating you as a member of the club with effect because you have failed to comply with what you had stated. And all the allegations, my lord, I'm not going into it. In the meantime, they file a petition, the suit is filed, essentially, my lord, because he wanted to contest the elections. Elections have happened. There are, I think, after that, my lord, 3 elections have happened. All the elections they've lost. That's beside the point, my lord. In the interregnum, my lord, the individual, the petitioner, has created various difficulties in the club. It's a members club, my lord. Comes with guests, unwelcome, my lord. They disrupt the functioning of the club. So the members are, my lord, against, my lord, having the petitioner as, my lord, a member of the club, or at least till the issue is decided, should not be bringing in guests. He may come, my lord. That is also the concession that I have taken instruction, because this can be resolved then. He may come, but, my lord, the other members that he is bringing, the other guests he is bringing, who are not members of the club, my lord, the difficulties, my lord, what they are doing in the club, my lord, is breaking the, my lord, decorum of the club. In that situation, there was a meeting which was convened. The moment there was a meeting convened, and it was a members meeting, my lord, so that the issue could be resolved, there could be a unanimous decision, and we could, my lord, understand what the members want. My lord, they approached the honorable court, file a contempt petition. That while the proceedings are pending, they've convened a special general meeting. We were hauled up in contempt. It was resolved thereafter, my lord. Now, my lord, before this matter is taken up, there's also, my lord, because it's continuing in nature. But now we have filed a petition, that is GA4, my lord, where we have prayed that, my lord, before this matter is taken up for consideration, let the SGM happen. It will be, my lord, maximum it will be 3 to 4 weeks. Where, my lord, will convene an SGM, will come back with what has transpired in the SGM, my lord, that will show the collective conscience of the members. But if the collective conscience is in favor of the petitioner, my lord, being a member, and, my lord, carrying on with the membership, but then we don't see a reason why, my lord, we should contest this, my lord, this entire proceeding.
My lord.
But today, my lord, if there's a collective consensus that, my lord, what is being done by the petitioner is not correct, not, my lord, attuned to becoming of a member of the club, my lord, then we'll present it before the court, while, my lord, GA1 is being moved by them. That is the reason, my lord, GA4 is required to be considered by the honorable court before GA1 is taken for consideration.
So
today, I understand,
why you
my lord,
not
the
argue
difficulty.
before that court? Why you get the matter
This
released
has-
from
But
the-
we,
This
my lord,
matter,
I'll indicate
GA4 is
what
taken
happened.
up. But it has to be specially assigned before, my lord.
It has been. We had indicated
Which
that
one?
on the last
This
day.
GF4,
It has been.
it has not been
It
assigned.
has been. We had
It
indicated
has
that
not been
order.
written under the heading.
Because
It has
the
been
last
specially
order
assigned.
we had indicated, my lord, show me the order.
My lord, what my learned friend is
My lord, we
submitting.
had handed over the copy of the order where, my lord, this is recorded. I'm sorry, my lord. Give me the order.
There is Justice Mukherjee has released.
Justice Mukherjee has recorded
Ah.
in the order, my lord.
What order?
I'll just indicate that.
It has to be specially assigned before, my lord.
Yes, yes, it has. It has. It has
The application appeared in the list. No one brought to the notice of this court. The matter has been marked as parted by the just so and so so and so.
the 10th April's order is, my lord, what your lordship is, my lord, looking.
10th
My lord,
April.
my lord.
Without noticing such, this matter was taken up for an order was dictated.
I'll indicate, my lord, what transpired that day.
Ah.
That we appeared, we moved the matter.
Ah.
My lord, we didn't take up this point because it was not according to us, my lord, part heard. So, my lord, we moved the matter. We indicated the facts.
Hmm.
My lord, it was then, my lord, this order was passed because, my lord, we failed to bring it to his lordship's notice because it was not marked part heard as such.
Hmm.
But, my lord, since the other matters, my lord, are being heard by your lordship,
Hmm.
that is why, my lord, this was a suo motu order by the court. And that's what is recorded, my lord. No one brought to the notice of the court that the matter has been marked as part heard. And, my lord, we were chided because of this. My lord,
No, that's it. No, 5th February. Where is the 5th February order? Only could not be concluded.
5th of February, my lord. It
One.
is not
5th of February.
My
Can't
lord,
be
5th of-
that is a GM1.
lordship.
J1. That is J1.
Could
That
not
is-
be concluded. Accordingly, hearing is adjourned.
Ah.
And because, my lord, we had submitted that this is to be heard before GA1.
So that cannot because this court cannot take
I
the
understand that. Lord, I understand that.
GFO.
Until and unless it is assigned by the Chief Justice before, my
GFO,
lord,
because
it cannot
Lord,
be taken.
GF1 is
I
part heard.
think, subject to consideration, my lord, my main advocate on record is not here today. What I remember is that, my lord, it has been assigned separately.
Nothing. There is no assignment here.
Then I'm wrong.
Because
Lord, because I
assignment order is
remember, my
coming
lord,
to the
there's-
assignment
Yes,
order
then
is
come
coming
back.
to
Lord,
the court.
then I'm at a loss because I can't make that submission then. It
Yes.
will not be right on my part. Yes,
Because that's why when the order, Justice Mukherjee's order has come, then I check the file and I find that only J1 has been kept parted by 5th of April.
My-
But 5th
My lord's
February.
order is there at 5th of February, my
5th
lord.
February. But
And the
on
reply
10th
is
of February, April, I don't know. 5th April, but the court has passed an order in the GF4. GF4 is not a part heard.
I'll indicate, my lord, why I was making this submission because I'll indicate later extra copy. But kindly have a look. This is what we had written for Act Second. This is the reason, Lord, I made that submission because I was instructed. I remember. This is the original, my lord.
Can I have a copy of this?
Yes, yes. For assignment, may I just hand over a copy? This is the original. Yes.
Yes. So what has happened to this?
That is, my lord. That is the reason I made that submission. They have applied. I know.
Hmm.
What is the outcome of this, my lord? I am not aware of.
No, there is no assignment.
That is what I'm not aware of, my lord. Then you have to follow up. My lord, I am.
Yes.
That is the reason, my lord, I made that submission. My lord, we'll come back then, my lord, because that will not be fair on my part to
My
make
lord
that
takes
submission
up-
now.
Or otherwise, if my lord
Hmm?
takes up GA1 today or any other day, that till today the interim order is there.
My lord, the reason I made that submission was, my lord, the only prayer, if your lordship kindly takes up, I'm not sure, my lord, whether I
हमारा
should
कोई
make the
assignment
submission,
order तो नहीं है ना?
whether I should make the submission for GA4.
GFO, that's why I am telling.
Then, my
That's
lord,
why
may I
before
come back in a
starting,
week's time? In a week's time, my lord.
no problem. I have no problem.
I wanted
Because-
to argue this. I'm ready for arguing, my
because
lord.
unless
GA4.
until because
I understand
court
that,
cannot
No, I
send
understand.
them
I understand that. My lord. It will
one
be wrong
matter
on
to
my
the
part
other
to make
court.
that submission.
Yes,
No,
yes,
my
so
lord.
that
It
would be
has
a-
to be the
No, no, I won't make that. I'm embarrassed, my lord, because the matter is fixed and I've come ready. I'm wasting the court's time, my lord. That's
That's
my
the-
embarrassment.
That is the fault of not on Mr. Bagh, my lord. That is they have to
kind of
follow, my lord. It has to be followed up by the advocate on record, my lord. Before the
So what can be done?
my lord, if my lord pleases to take up GA1 or if it pleases to take up the GA1 any other day, the interim order may be extended, my lord. I don't have any problem if GA1 is taken up today or any other day. The GA1 is the interim order of GA1 is expiring today, my lord. The last order, 23rd of July is ordered, my lord.
J1 you already argued.
My lord, Mr.
We
Thakkar
were-
had had
we had made
what
extensive
had,
submissions.
extensive submissions were made. My lord, Mr. Thakkar was arguing the matter. Thereafter, my lord, was due to paucity of time, my lord, time to time, the
Right.
interim order has been extended. Affidavits has been completed. Our submissions would take half an hour to complete our submissions. They would give the reply. we
You know,
would
they
be
can
further.
conclude their submissions today, my lord. We will then come back on the next day. We'll argue, and also, my lord, in the meantime, I believe we can also indicate.
Okay,
my
you
lord,
conclude it. You are appearing for J1, you are not appearing.
G1
Yes, yes,
very-
it is appearing for
Okay.
J1.
But in fact, when Mr. Thakkar had made that submission, my lord, in GA1, we had indicated, my lord, that we are going to make this prayer for a SGM. We didn't have an application then, my lord. So we had indicated, my lord, if this is to be resolved, if this is a way out, my lord, it can be resolved. The entire dispute can be resolved. It is for that reason, my lord, the GA4 has been filed.
Go before the mediation.
But mediation, I do not know how far it will be resolved after this protracted litigation. I'm not very sure, my lord.
This is a dispute between my client, the petitioner, who is a member of the club, who was elected as a president, vice president,
And not
several times.
re-elected after 3 elections. That's the problem.
That's the
That's where the
different issue.
issue.
What is the main problem?
The main problem is they want my
My lord,
client to
financial
be thrown out
irregularities. I'll
from the-
indicate, my lord,
But
financial
that is
irregularities.
not-
That is
that
the
is-
allegation. From all the letters, this is borne out. Where, my lord, we have stated that there are defalcations of money, and that is the reason, my lord,
forensic report is
Defalcations on money by
by the petitioner. And that
There's
is
a
why, my lord,
forensic
those
report,
letters
audit
of
has-
termination.
auditor
That
has
is
been
the reason.
forensic report.
That's
CBI
the-
was appointed. A clean sheet has been given to the petitioner,
what
and
is your prayer in the suit?
the prayer in the suit. My lord, if my takes up my application,
What is your suit
Declaration,
for?
my lord, that the
Declare-
letter which we have
letter by
issued of
which-
termination, that be declared as null and void. That's the,
that is the main prayer, my lord. If takes
You have
up
been
my
terminated.
yes, my lord.
has been terminated. Not to give effect, my lord. If my lord takes up volume 2, page 139, the plaintiff is annexed. Decree for a declaration that the plaintiff is a regular member of the Dalhousie Athletic Club, defendant number 1 society, has a right to vote and contest the AGM to the defendant number 1 society, or to participate in the activities of the society being defendant number 1. That is the prayer A.
Is there any criminal proceeding initiated?
No, nothing. There's a clean sheet,
If
forensic
there's no
report.
clean sheet, I'll indicate when my turn comes. What my learned
Forensic
friend is
report
saying.
is there.
Today, my lord, they are enjoying an interim order, so that effect of the termination letter is not being given to. My lord, so if my learned friend wants to conclude his submissions, he may. May I come back on the next day and try and move the GA4, my lord, after having it
That's
assigned
why
to your
if
lordship?
you want to be J4, then all the things need to
Indeed,
be
indeed. That is the reason. my
taken
lord.
together.
So, my lord, it can be done together. May I only pray for a short date, my lord?
Though the matter is fixed today, especially fixed today for hearing of GA1 of 2023 at 11:30 a.m. But it is found that by an order dated 10th April 2025, His Lordship, 10th April 2025, Honorable Mr. Justice Arindam Mukherjee J has released GA4 of 2025 on the pretext that the matter is kept parted by this court by an order dated 5th of February 2025. This court has gone through the order dated 5th of February 2025, wherein it reveals that this court has kept the matter parted only with regard to GA1 of 2023 and not GA4 of 2025. Learned counsel appearing for the defendant who has filed GA4 of 2025 raise a communication dated 9th of 9th July 2024 addressed to the registrar original site. It is you have to write to the registrar original site.
Register original side, my lord.
Registrar original site for assignment of GA4 of 2025.
I knew it was the OSD
No,
who it was to be written to. my lord.
Not-
I knew
it
that.
has to
So
be
that
written.
I'm
That's why
For assignment, it has to be written before the register original side, my lord.
OSD.
I thought so, my lord. So
OSD.
I was
because
taken aback by seeing.
whenever I had practiced this
Indeed, my
was,
lord, that is what I knew, my lord. So
I know. Now I don't know whether it is changed.
No, no,
this I'm not aware of, my lord. That is the reason I saw
When
the
you
letter.
when I used to come to here and to placing, then directly we have to write to the OSD and to assignment.
Right.
I don't know
But
whether
that is why I, my lord, said,
that's why
because this
in
is
the register. That's why this has not been taken into consideration.
No, my lord.
maybe I'm not sure. My lord.
What I have the knowledge, my lord, in original side, It has to be written to the register only, original side.
Maybe.
And
Maybe.
OSD is for the appellate side matters.
Okay,
And
might be because क्या बोला? GA4 of 2025,
GA4 of 2020.
25.
25.
25.
No, 24 most probably.
25. 25.
So how this?
GA4 of 2025, the order is of 2025, my lord.
You'll give the communication which are given to the register. क्या बोला? No, it's no communication dated 25th of July 2025. And it's on your side with the request to place the matter before the Honorable Chief Justice for assignment of GA4 of 2025 before this court for hearing of the said application along with GA1 of 2025. Full stop. Full stop. This court find that GA4 of 2025 is not assigned before this court. 2025 not assigned before this court till today. So learned counsel appearing for the dependent who is the applicant in GA4 of 2025 press for some time so that he can pursue the matter for assignment GA4 of 2025 before this court. In view of the above, the case is adjourned. Let the matter appear on 25th of August 2025. The interim order is extended till Friday. No, 22nd.
22nd, my lord. I'm in some difficulty.
Then
but I may not
29th.
disturb.
29th August. And interim order is extended till 4th of September 2025 or until further order, whichever.
I'm very deeply aware.
Item number 5, Your Lordship, I am for the petitioner. This is an application for judgment upon admission, Your Lordship. We have already completed our submissions.
Who is for the other side?
But at 2 occasions, they have taken time. When, Your Lordship, I completed my submission, they took time, Your Lordship, that the matter was fixed specific time. They, Your Lordship, chose not to appear, and last occasion also, 25th of July 2025.
Okay, I am fixing a date as to mention. Finally, written notes of argument.
Such. One.
None appears on behalf of the defendant. It is found from the record that on 24th of June 2025, the learned counsel for the plaintiff has concluded his argument in connection with GA-Com 2 of 2025. And the learned counsel for the defendant pressed for time. Again, the matter was listed on 25th of July 2025. No, 15th of July 2025. But on that day, none appears on behalf of the defendant. Again, the matter was fixed on 25th of July 2025. On the said date also, none appears on behalf of the defendant. No, on the said date also, the defendant has prayed for time. Accordingly, case is adjourned with the rider that no further adjournment shall be granted on the next date fix. Today, when the matter is called, none appears on behalf of the defendant, and no accommodation is sought for. In view of the above, the parties are directed to file the written notes of argument within a week. List the matter on 21st of August 2025 under the heading to be mentioned only for filing written notes of argument.
Your Lordship, permission, Lordship, because the facts were so clear. Should I include 2 judgments of Uttam Singh Daggal and Karam Kapai? Lordship, all the order 2012-16.
Gratefully.
Six. My lord, I am the plaintiff in this matter.
Yes.
I am plaintiff
Yes.
and respondent in this matter.
Hmm.
This is petition filed by the defendant.
What is the GF5?
GFI is for amendment, amendment of written statement, my lord.
Amendment in the written statement.
Yes, my lord.
Yes. What is our objection?
The amendment is sought for by my lord. It totally contradicted to the original statement, my lord. No documents were earlier disclosed. They sought for it. May kindly see.
Where is the proposed amendment?
Proposed amendment, page 1.
Page?
Just a minute, my lord. 259, my lord.
Huh?
259.
Page 59.
Yes, my lord. 259. Original plate, two space, two system, and we want to paragraph 5A, 5B. This is the new story, and this is not related to the plaintiff, my lord. This is agreement between the third party and the defendant, my lord.
Record or not?
My lord, my application, my lord, for amendment of written statement.
I am dismissing.
My lord,
For the 10 minutes I am waiting, nobody's up here.
my lord, we were here.
Okay, no problem.
My lord, kindly, my lord. Kindly. My lord, on last occasion, I moved this application. My lord was otherwise because lordship may kindly recollect. My lord, we initially suffered a my lord summary judgment. Then my lord, we preferred an appeal. My lord, in the appeal court, it was set aside. Now, my lord, the stay application, my lord, it's a change brief. We, my lord, given the facts, same facts. My lord, only the language was changed. Now, my lord, lordship was pleased to ask on the last occasion. So, for my lord, the disclosure of documents. Now, my lord, we have not been, my lord, the conducting advocate. His wife died, my lord, day before yesterday, and she was admitted in hospital, my lord, for last 4 months. Instruction, my lord, we are lacking. And one, my lord, technical difficulty, my lord, I must tell your lordship, my lord, the statement of truth has not been given.
Huh?
It's not there. Otherwise, my lord, so far, my lord, we have been able to, my lord, the documents, those are available with us. The documents are also, my lord, more or less same. But, my lord, the original written statement that I need to compare, my lord, I couldn't get that. If your lordship kindly give us, my lord, little, my lord, only limited accommodation, my lord, we will compare and come back.
You filed this application 2024.
My lord,
Then,
my lord. Only this little accommodation.
as per prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 9th September 2025.
Grateful.
Next.
9th September.
Lord, I appear for the plaintiffs.
Lord, the defendant, my lord, their application for rejection of the plaint, my lord, they've taken out an application.
Who is for the defendant? Plaintiff.
Lord, I appear for the plaint.
Who is for the defendant?
My lord, I'm being led by Mr. Rupak Ghosh.
Yes, my lord, I'm there, my lord. The point your lordship will remember, we had taken out an order 7, a demurrer application saying, my lord, that this had to be filed as a commercial suit.
This has to be filed as a commercial suit.
Because, my lord, that Deepak Polymer's case, when this was filed, Deepak Polymer's case was holding the field. And that had, I'm sorry, non-commercial suit, because I'm sorry, my lord, non-commercial suit, because, my lord, that point of time, it was clearly held that if it's my lord, this scenario of, my lord, 106 notice, then it has to be a non-commercial suit. But they have filed it as a commercial division. And my lord knows, my lord, the validity of a suit has to be decided on the date of filing. Date of filing, that was the law. So that is what we had argued. Now, my lord, that matter is still pending. I believe Mr. Ghosh, Mr. Shomava Ghosh was appearing on behalf of the plaintiff.
That is over. So division bench is order. Have you not gone through?
Well, that division bench order, even if it has, whatever it has clarified, my point is a little different. I am saying as on the date of filing of the suit, there was no division bench. There was Deepak Polymers which clearly held as on the date of filing of the suit that any application which is any suit, any lease which is determined by 106 notice is, my lord, a non-commercial suit has to be filed. How do they get out of that? And this division bench judgment does not say that this, whatever they have held, will have retrospective effect. But let Mr. Ghosh make his arguments. I mean, I can meet his point. That has been my argument. Let Mr. Ghosh make his argument. How he says.
Okay. Yes.
May I just start, my lord?
Yes.
My lord,
Start, then you have to complete. Yes, Mr. Ghosh.
Mr. Ghosh is in the library, I believe. Yes. I believe we'll have a good lunch then. Now, my lord, the issue which has been raised is pertaining to, my lord, the maintainability of the suit in, my lord, the commercial.
In the commercial.
Yes, my lord. Now, Mr. Ghosh had relied upon, my lord, the judgment passed in, my lord, Deepak Polymers. Where, my lord, if it's a suit which has been instituted pursuant to, my lord, expiry of the time provided for under 106, my lord, that suit, my lord, would essentially not be a commercial dispute, in as much as, my lord, the cause of action in a suit arising out of expiry of time under 106 would be a suit which is dependent solely on the factor of the expiry of the lease, and the inter se relationship between parties, whether the transaction was commercial or not, or the agreement was commercial or not, loses relevance, if I may say so, my lord. This judgment, my lord, of Deepak Polymers, my lord, was holding the field for the longest period. Mr. Ghosh took out this application because, my lord, it is his case that the law that is prevailing as on the date when the suit has been filed would be the applicable law. And admittedly, on the day when the suit was filed, the Deepak Polymer judgment was in place. There was only one issue, my lord, which has to be taken into consideration, apart from, my lord, the larger bench judgment of T. Thompson and the other factors which have also now come in. On the date when the suit was instituted, my lord, the judgment of Deepak Polymer was a single bench judgment. In past, in, my lord, a revisional application. During that period itself, my lord, there are judgments of this court of coordinate benches where 106 issue was raised, considered, and, my lord, despite of which, my lord, Deepak Polymer was not followed. So, my lord, there is a judgment of Justice Bhattacharya. There's your lordship's judgment. So, my lord, it is my respectful submission, firstly, that Deepak Polymer could not have been said to be holding the field as such, or the final statement on law based on which, my lord, the plaint would be guided. Secondly, my lord, the question as to the applicability of the law once there has been a judgment which has been passed by a larger bench, or even if it would have been the division bench, the regular course of, my lord, understanding in such cases where, my lord, a law has been laid down by way of a judgment, that it operates as a declaration of the law retrospectively, unless and until the judgment by itself says that this law shall operate prospectively. This is, my lord, the significant distinction between, my lord, a judgment and a statute. A statute will always operate prospectively as the declaration of law, unless, my lord, again, the statute operates retrospectively. In case of taxing statutes as well, there are provisions, my lord. In case of judgment, my lord, a judgment operates as a declaration of law as it stood always, as if. So, my lord, it is my respectful submission that the larger bench decision, my lord, which has ultimately laid down, my lord, what is the effect of a 106 notice, taking into consideration Deepak Polymer, your lordship's decisions in T. Thompson and the other judgments as well, is that, my lord, 106 notice is the culmination, effectively, of the contractual relationship which was preceding the issuance of the notice. And it is not for the courts to ignore the contractual relationship prior thereto. On the contrary, my lord, the larger bench has arrived at the conclusion that the final effect of severance between the parties is the 106, and the expiry of which culminates into filing of the suit. My lord, even if we say that 106 notice, this is something, my lord, which is which I may just indicate to your lordship, my lord, it is settled law, which I'm sure Mr. Ghosh will agree with me. My lord, in case of a relationship which is commenced under the Transfer Property Act, whether it's based on a registered document or not based on a registered document, even the filing of a suit is a notice for eviction. So, my lord, the point of 106, if we are going into, there, my lord, it is now well settled that in light of, my lord, the decision of, my lord, the Honorable Larger Bench, I humbly submit, my lord, that the application today is no longer primarily, my lord, that the to say so, the limbs of the application have now been taken away.
Yes.
Now, my lord, may I? Now, my lord, if I may take the application once, my lord, which is GA5, my lord. Yes. তোমার application দেখাবো না?
Yes.
So his principal case is paragraph 3. The bare perusal of the plaint would show that the basis of the plaint is a lease originally entered into by and between the parties on 18th of June 1956, which was extended from time to time, last of which was executed on 30th of May 2023. The case of the plaintiff is that the lease has been terminated by the plaintiff, where letter of termination dated 24th of March 2022 has been issued under 106 of the Transfer Property Act 1882. The plaintiff also claimed in paragraph 17 of the plaint that the suit relates to commercial transactions, and it is a fact that the defendant carries on business of supply of electricity to its consumer on commercial basis. So it is an admitted fact that the nature of the immovable property and the present user is commercial exploitation. Sorry. The petitioner states that the plaint in the suit has been affirmed such and such. Suit has been presented 29th of April when clause 12 leave has been obtained in respect of the plaintiff. As per the case status available, the Honorable Court, the instant suit was filed on 28th of April 2022. The petitioner states that as on the date of filing and admission of the suit, this Honorable Court at Calcutta, in a decision rendered in Deepak Polymer, reported in 2021, Volume 1, Calcutta Law Times, had categorically held that suits for eviction based on a 106 notice issued under Transfer Property Act squarely arises out of statutory right having no direct nexus with the lease agreements in respect of immovable property is concerned. The question of such suits falling in the category, it should have been falling in the category of commercial disputes and consequently classified as commercial suits do not and cannot arise. The said judgment was rendered on 11 June 21. No appeal was preferred on the said judgment of order up to 19 July. On 28th April 22, the present suit was filed and admitted. Hence, the present suit could not have been filed as a commercial suit in the commercial division of this honorable court and is liable to be dismissed with exemplary costs. So this is the case made out in the application. Now, my lord, if your lordship is pleased to consider but you'll kindly see this judgment, which is, my lord, passed by a coordinate bench. This is an unreported judgment. So, my lord, I'll first meet the point that Deepak Polymer wasn't the settled law even on the date. Because today, my lord, it's now, to be very honest, subject to what Mr. Ghosh submits. Perhaps this entire argument has become academic in light of, my lord, the larger bench's decision. My lord, if your lordship sees, my lord, page 2 of the judgment which I've handed over, the second paragraph from in the middle, the fifth line from top. In the present suit, the petitioner has filed for judgment on admissions and for an injunction restraining the respondents from creating third-party rights in the suit property, wherein an ad interim injunction was passed on 19 November 2020 against the respondents from creating third-party rights in the demarcated area of the suit property. The respondent number 1 thereafter filed an application for rejection of claim, my lord, under Order 7 Rule 11 of the Code of Civil Procedure, which was disposed of. The petitioner thereafter instituted CS number 105 for recovery of khas possession. According to a learned counsel for the petitioner, the suit pending before a civil court should be transferred since the parties are the same and both the proceedings relate to the same suit property, whereby common questions of law and fact appears. Counsel submits that both suits should be heard by this honorable court to avoid overlapping decisions for the purpose of saving litigation costs. Learned counsel for the respondents opposes the prayer for transfer by relying on the judgment passed by the single judge of this honorable court in Deepak Polymers, wherein it was held that an eviction suit for recovery of immovable property is not a commercial dispute under the Commercial Courts Act. A special leave petition filed from the said judgment was dismissed by the Supreme Court. According to counsel, the present suit is also a suit for eviction based on a notice issued by the petitioner under Section 106 of the Transfer Property Act and would hence be covered by the judgment of the coordinate bench, which has been relied upon. Counsel also submits that since the existing suit filed by the petitioner is in the commercial division, no useful purpose would be served by transferring the suit before the civil court to extraordinary jurisdiction of this honorable court. Upon hearing learned counsel appearing for the parties before this court, it appears that the main hurdle to the relief sought for by the petitioner is the judgment of the learned single judge passed on 24th June 2021. That is Deepak Polymer and the other civil divisional applications before this court, all of which was disposed of by the judgment. Since the respondents before this court have relied on this said decision to contend this present suit is not maintainable as a commercial suit, the correctness of such contention should first be dealt with. The revisional applications in Deepak Polymers were filed against applications for return on complaint on the ground that commercial suit in which the suits were instituted does not have jurisdiction to hear the suits. The court below rejected the application filed under Order 7 Rule 10 of the CPC. The question before the learned single judge was whether a suit for recovery of possession of immovable property under Section 106 of the Transfer Property Act constitutes a commercial dispute under the provisions of the Commercial Courts Act 2015. Upon construing 21C7 of the Act, the court held that suits which are primarily filed for recovery of possession of immovable property under 106 of the TP Act and from a refusal by the defendants to comply with the notices issued by the lessor under Section 106 is based on a statutory right independent of any clause in the lease agreement. The court hence concluded that disputes lay outside the purview of 21C7 of the 15 Act and is not a commercial dispute. Upon considering Deepak Polymers, this court is of the view that the question which was before the court is that decision was the issue of maintainability, whether the concerned court is not being a commercial court had the power to entertain the suits, and whether the suit for recovery of immovable property is a commercial dispute under provisions of the 15 Act. Both the aforesaid issues would assume relevance at the time of determining whether such a suit should be heard by a commercial court. Such question would therefore fall for consideration only after the suit is entertained and the parties are heard on the merits of the dispute and not before. Since the instant cases for transfer, the suit pending before the civil court, simplicity on the ground of commonality of parties, subject matter and issue, the suit was transferred. So, my lord, the issue with regards to the commercial court is to be determined whether on the merits and not merely on the aspect that 106 whether it should be treated as a commercial dispute or not. So, even, my lord, considering Deepak Polymer, this honorable court, while exercising an extraordinary power under, my lord, the letters patent, was pleased to transfer a suit from the city civil court, which is admittedly does not have a commercial division, to the commercial division of this honorable court. So, my lord, Deepak Polymer wasn't a law which was being constantly followed. There are other judgments as well. In 227,
No, here the court has held that this
yes,
this is to
so
be
it is
taken in
on
on
merits.
merit,
Yes,
by way of
the
issue
issue
or
of
whatever it
yes,
may be.
the issue is this, that it is not an issue regarding maintainability, but the issue has to be examined on merit.
But here the Mr. Ghosh has filed an application, now that has to be decided
Yes.
on merit.
Yes, my lord. That 106 itself would effectively be that 106 notice is when it's issued, that detaches itself from, my lord, the preceding relationship which followed. That is Deepak Polymer. I'm only showing, my lord, only to the effect that the law as laid down by Deepak Polymer wasn't firm. There were views which varied from the view taken by the coordinate bench. My lord. That is all. That is my first endeavor, which in any event today, my lord, with the deepest of respect, perhaps is, my lord, not any more res integra. So this is a judgment again in a coordinate bench, my lord. This is 2021 again. Lord, will kindly see, my lord. But paragraph 20. The coordinate bench in Deepak Polymer, while dealing with a suit for recovery of possession of immovable property under section 106 of the Transfer Property Act, held the dispute involved in such suit is not a commercial dispute, as the cause of action therein arose by virtue of rights conferred under section 106. The said decision is distinguishable on facts, as the plaintiff in the instant case has played for declaration of rights under a subsisting leave-in license. Thus, this court is of the considered view that dispute involved in the instant suit is a commercial dispute. So, mere issuance of 106 and filing of a suit based on it would not effectively take it out of the purview of, my lord, being a commercial dispute. Lastly, but there are several judgments on those lines. My lord. I can provide a compilation because I don't want to hold back your lordship on this now. So this is relevant after the relevant. Lord, I'm sure, my lord, your lordship has been troubled with this judgment sufficiently. I don't want to trouble your lordship with it, except, my lord, the ultimate finding, my lord, at page 85, my lord, paragraph 122, where, my lord, it's answered.
Taking the trouble, I have made that.
Yes, my lord. Your lordship, then your lordship has passed orders both ways. Firstly, your lordship declined and following Deepak Polymer's, but Mr. Thakkar convinced your lordship to take a different view. Well,
Yes.
question number A at paragraph 122. whether after issuance of notice under 106 of the Transfer of Property Act, the defendant or the parties cannot rely on the agreement, lease deed as the case may be. Lease agreement is to be looked into and considered for deciding the nature and character of jural relationship of landlord and tenant between the parties. That is to say, whether the lease agreement is for manufacturing or agricultural purpose, upon which will depend validity of the notice under section 106, the answer is in the negative. Whether only on the basis of the case initiated under section 106 of in the 82 Act, it can be said that the court cannot look into the agreement between the parties and thus the suit cannot be treated as a commercial suit. The answer is included by necessary implication question A and answered in the negative. So, my lord, merely because, my lord, the issuance of 106 is the basis of institution of the suit, that by itself will not preclude the court from considering whether, my lord, the issues are commercial, the relationship between the parties is commercial or not. Now, my lord, insofar as the effect of, my lord, declaration of law, well, for that, my lord, I would be relying upon two judgments. Firstly, my lord, it's an English judgment which is quoted thereafter in the Supreme Court. I would rely upon the English judgment first, my lord. This is reported in SCC online. Mr. Ghosh is trying to be extraordinarily expressing his humility, trying to say he doesn't have copies of these books. What he has, I don't want to disclose. He has a
Yes.
We'll be enjoying his hospitality soon. My lord, if your lordship, this is 2005 volume 3 weekly law reports, page 58, my lord. Now, if your lordship is pleased to turn to paragraph 43, my lord. I turn to the present case. In my view, it is miles away from the exceptional category in which alone prospective overruling would be legitimate. No doubt, over the years, the clearing banks, including the respondent bank, have to some extent relied upon C.F. Gorman, reported in, my lord, 1979 2 Lloyd's reports, when formulating and using their standard forms of charges on book debts. But banks and others who lend money on security of charges on the company's undertaking are sophisticated operators. There is no reason to oppose this decision lulled them into a false sense of security. The C.F. Gorman case was the first instance decision. It cannot have been regarded as definitive settling law in this field. It cannot have been regarded, however, if the firm and unanimous decision now being given by the House were given prospective effect only, the result would be that in many existing liquidation, preferential creditors would be deprived of the priority Parliament intended they should have. I would reject the bank's submissions that this decision of the House would have only prospective effect. I would allow the appeal accordingly. So this is, my lord, the finding of, this is, my lord, comprised of, my lord, 5 judges of the Honorable, I think, my lord, the High Court, or, my lord, the House of Lords.
House of Lords.
Yes, House of Lords. This is House of Lords decision. Well, paragraph 46, my lord, thereafter. On the issue of prospective overruling, all the lords, my lord, who presided over the bench, my lord, have arrived at the same conclusion. Lord Staine's opinion on this. My lord, paragraph 46 is following what had fallen by the preceding decision of Lord Scott. I would also make the order which Lord Scott proposes. So, my lord, following, my lord, Lord Staine had also done the same. Then, my lord, paragraph 65, my lord. Should C.F. Gorman be overruled prospectively? Well, paragraph 65. Changes in the law do not occur in a vacuum. Much is likely to depend on whether the change affects situations before the change occurs, or whether it affects only situations that come afterwards. On the whole, legislation affects the future only and not the past, although awareness of what is to come may well influence the way people conduct their affairs before its commencement. The reverse is true of judicial decisions. So, my lord, as I was trying to state earlier, my lord, judicial decisions, my lord, the contrary follows, that it will be effective retrospectively as a statement of law. Paragraph 71, my lord. The question then is whether it can ever be consistent with the exercise of its judicial power for the House to declare that its decision, which it takes which changes the law, is not to affect events or things done in the past, but only events or things done in the future. While I recognize the force of Lord Gough's argument to the contrary in Keilworth Benson, I think it would be unwise to say that the power to do this can never be available in any circumstance. The speeches that were delivered in R versus Governor of Brock Hill Prison show how reluctant your lordships have been to engage in this debate. It is no doubt true that in almost every case that can be imagined, the exercise of judicial power, which will require the House simply to declare what the law is, with the inevitable result that it will apply to other comparable cases whenever the events occurred. But it is not possible to predict the future with complete confidence. And it seems to me that the question whether this technique should be adopted remains an open one. My lord, then, my lord, a passage is quoted from, my lord, one of the
Observe that
commentaries.
they apply the admittedly new rule respectively be blatantly legislative, however,
Yes, my
they
lord.
are otherwise normal. Yes.
Paragraph 72, question whether such a declaration will ever be consistent with the exercise of judicial power must, in the end, depend on the issue that the House is being called upon to decide. In Arthur Simmons, for example, I said that I was of the opinion that the decision in that case, which changed the law about the immunity from the suit of the advocate, should take effect only from the date when the House delivered its judgment. That was a highly unusual case in the Court of Appeal. It was held that the solicitor who had acted as their client's advocate and their conduct was not so intimately connected with the conduct of the case in court as to attract the immunity. I said at the outset of my speech that the grounds which the Court of Appeal had given for its decision were entirely sound, sufficient, and satisfactory, and it was unnecessary for the disposal of the appeal to examine the fundamental question whether the core forensic immunity which the House had recognized in Rondell Worsley could still be justified on the grounds of public policy. But the opportunity had been taken of considering whether the rule that was established by that case could still be made to be justified. The focus of attention was shifted quite deliberately to this issue. The House was no longer interested in the question whether the Court of Appeal had been right to say that solicitor's conduct was such that as not to attract the Court of Immunity. So I did not regard it as necessary for the disposal of the appeal to say that any change as regards the immunity rule should operate retrospectively. On the contrary, as I said at paragraph 710, page 710, I consider it to be legitimate exercise of your lordship's judicial function to declare prospectively whether or not the immunity, which is the judge-made rule, is to be available in the future, and if so, in what circumstances. I continue to think that this approach to the exercise of judicial power in that case was legitimate. There was no need, in order to do justice between the parties to the disputes, for the decision in Arthur Hall to be applied retrospectively. Advocates had arranged their affairs since the decision in Rondell Worsley on the basis that in their conduct of cases in court, the core immunity was available. Recognizing the importance that is to be attached to legal certainty, there was much to be said for the view that is, in their case, the decision to remove immunity would operate respectively only and not retrospectively. Where the future may lead to us, we cannot tell. Paragraph 74, my lord. So, like my noble and learned friend Lord Nichols of Birkenhead, I would not rule out the possibility that in a wholly exceptional case, the interests of justice may require the House, in the context of a dispute about the state of common law or even about the meaning or effect of statute, to declare that its decision is not to operate retrospectively. But I would not consider that approach to be appropriate in this case. The single most important point which indicates the contrary is that if the decision to overrule Steve Gorman were to be applied prospectively only, it would deprive the preferential claimants of the priority to which, on a correct view of law, they are entitled to under Section 175(2) of the 86 Act. I do not think that it is open to your lordships in the exercise of the judicial power to deprive a party to the litigation of a legitimate remedy that has undoubtedly been given to him by statute. for the reasons given by Lord Scott and Lord Walker, and for those further reasons of my own, I would hold that the decision C. Gorman was wrong and should be overruled. I allow the appeal, my lord. Finally, my lord, paragraph of the same decision, my lord, paragraphs, I'm not placing it any further, my lord, paragraphs 122, 127, 129, and lastly, I'll just place 161 to 164, my lord.
122.
127 and 129. And my lord, 165 onwards, I'll just place. This is the last opinion, my lord. My lords, I have had the advantage of reading in draft the speeches of my noble and learned friends, Lord Nichols of Birkenhead, Lord Hope of Craighead, Lord Scott of
Which paragraph you are reading?
paragraph 165, my lord. Starts at, my lord, page
Yes, got it.
60, I think, page 64. Yes. For the reasons they give, I too would allow this appeal and make this order proposed by Lord Scott, whilst I would not rule out the possibility that this House may one day think it right to declare the law with prospective effect only. I am quite clear that this is not the case for such an order. Appeal allowed with costs in House. That's so. This decision has been followed by the Honorable Supreme Court, my lord. This is reported, my lord, AIR 2007, Supreme Court 1034. In fact, my lord, I think in our Commercial Courts Act case, my lord, the Patel automation, my lord, it has taken into consideration all of it and has stated that the law as laid down by Patel will operate prospectively. So that was one case where it thought it deemed it fit to operate prospectively. Now, my lord, in this decision, my lord, Justice Sinha's judgment, paragraph 14, my lord. In our own easier Indian language, my lord, it has been now stated. Indian English, it's now stated. Paragraph 14, my lord. The effect of declaration of law, the rule of stare decisis, and the consequences flowing from a departure from an earlier decision has been considered in great detail by the House of Lords. Opining, my lord, then the judgment is quoted. Lord Nichols of Birkenhead, speaking for House of Lords, clearly held that power to apply prospective overruling is available to the House of Lords also. And then, my lord, the decision which permitted prospective overruling has been done. So, my lord, the decision has, my lord, of National Westminster Bank has been followed by the Supreme Court. The relevant paragraphs: people generally conduct their affairs on the basis of what has been understood the law to be. The retrospective effect of a change in law of this nature can have disruptive and seemingly unfair consequences. Prospective overruling, sometimes described as non-retroactive overruling, is a judicial tool fashioned to mitigate these adverse consequences. It is a shorthand description for court rulings on points of law, which to greater or lesser extent are designed not to have the normal retrospective effect of judicial decisions. Prospective overruling takes several different forms. In its simplest form, prospective overruling involves a court giving a ruling of the character sought by the bank in the present case. Overruling of this simple or pure type has the effect that the court ruling has an exclusive prospective effect. The ruling applies only to transactions and happenings occurring from the date of the court decision. All transactions entered into or events occurring before that date continue to be governed by the law as it was conceived to be before the court gave its ruling. Other forms of prospective overruling are more limited and selective in their departure from the normal effect of court decisions. The ruling in its operation may be prospective and additionally retrospective in its effect as between the parties to a case in which the ruling is given. Or the ruling may be prospective and additionally as between the parties in the case in which ruling was given and also as between the parties in any other case already pending before the courts. There are other variations on the same theme. Recently, Advocate General Jacobs suggested an even more radical form of prospective overruling, he suggested that retrospective and prospective effect of a ruling of European Court of Justice might be subject to a temporal limitation, that the ruling should not take effect until a future date, namely when the state had reasonable opportunity to introduce new legislation. My Lord, Lord Nichols of Birkenhead, speaking for the House of Lords, clearly held that power to apply retrospective is available.
Paragraph 18.
Yes, my lord. Finally, my lord, paragraph 18. Moreover, the judgment of the full bench has attained finality. The special leave petition has been dismissed. The subsequent division bench, therefore, could not have said as to whether law declared by the full bench would have a prospective operation of the law. The law declared by court will have a retrospective effect, if not otherwise stated to be so specifically. Full bench having not said so, the subsequent division bench did not have jurisdiction in that behalf. So, my lord, the operation of law of T. Thompson, as laid down by the full bench, the larger bench in this case, would operate from as if it was always the law as it stood since the inception.
Declare, that is a declare.
Yes, it's a declaratory issue. Lord, these are the judgments that I want to cite. Well, there are other coordinate bench decisions of contemporaneous time when Deepak Polymer was there.
Yes.
But Deepak Polymer was, in one case, my lord, it was not cited, but the court in a 106 situation granted eviction. So, my lord, I am not citing that decision, but these decisions are there. These are my respectful submissions.
Okay. Yes.
Lordship keeps it, my lord, I think on the 18th, my lord, Mr. Ghosh will be
Has
there.
concluded his argument in reply to the application filed by the defendant with GA Com 5 of 2025. Due to paucity of time, the counsel for the defendant could not reply the same. And he joined the argument made by the counsel for the plaintiff. The counsel for the defendant could not reply that and could not make rejoinder to the argument made by the counsel for the plaintiff due to paucity of time. Accordingly, case is adjourned. Let the matter appear on 21st.
Great.
Next.
My lord, I was addressing your lordship, my lord, on the point of rejection. Right.
I just want to indicate to your lordship and to my learned friend that this is an order 7 rule 11. But I've found out from the orders passed by your lordship, lord, hearing had commenced November 20, 2024. And if your lordship sees the order sheet, at least 3 hearings have already taken place on an order 7 rule 11 opening submission. My chance has not yet come. But I was humbly submitting to your lordship, lord, that in case my learned friend has anything, let him give a summary and file a note. I will only take, my lord, 15 to 20 minutes time to give my reply, because the problem is, lordship says this is a partition suit. And I have already filed 2 supplementary affidavits to bring on record that during this period, one by one, the properties are being dissipated. So if I foresee that your lordship may be with me, the suit stays, then I really do not know, my lord, what is the partition I will ask for. So my humble submission, my lord, let my learned friend complete as soon as possible, and my lord, give a written note. Let me complete my reply today. Otherwise, I will not be able to urge my interlocutory application in the partition suit.
Yes.
My lord, before I start on the rejection of plain, my lord, allow me to, my lord, disabuse your lordship's mind on this extreme, my lord, submission of prejudice. My lord, the interlocutory application was filed 9 months after the filing of the suit. And the interlocutory application is without any particulars. By supplementary affidavit, they are trying to, my lord, supplant the case made out.
What you are selling, whom you are selling, it is not possible for me to know.
Okay, so as on the date of filing of the suit, he had no apprehension that I was selling. Now, my lord, the interesting part is that there is already a partition in 2011.
Whatever it may be, now you have got the 1 hour.
Yes. My lord, we have got, my lord, this alleged partition suit.
Yes.
Lord, we've got two principal points. A, it does not qualify to be a partition suit. B, ex facie barred by the laws of limitation.
In the partition suit?
Yes.
Yes.
Now, my lord, kindly take my application for rejection of plaint, which is GA 5 of 2023.
Yes.
My lord, kindly come. I'll take your lordship to some of the relevant governments.
Have been said, but the plaint has been placed umpteen number of times.
Yes.
So, my lord, if I have to address your lordship, my lord, and if my learned friend keeps interrupting,
You can't place everything every time.
so, my lord, now whether I can or I cannot, my lord, this is up for the judge to decide what I can or what I cannot, and how much I will say, my lord, that is up to me. You cannot, as a plaintiff in a suit which is not maintainable, my lord, dictate the defendant how he will address the bench.
Yes.
My lord, kindly come to the relief, which is at page 19 of the plaint. Allow me to say how misconceived the suit is. My lord, kindly first take prayer A. A decree for declaration that the plaintiff, comma, the defendant number 1 and 2 are the joint owners. Now, my lord, kindly read this with the cause title of the plaint.
Yes, I take a note of you are already arguing.
Then your lordship will find, why I'll tell your lordship will find from defendant number 8 to defendant number 14, 15 are companies. So, decree declaration that the plaintiff, the defendant number 1 and the defendant number 2 are the joint owners of the companies, comma, businesses, assets and properties as mentioned in Annexure B, which is, my lord, at page 42.
Yes.
Now, my lord, if you are asking for a declaration of joint ownership,
yes.
So, my lord, that means you must, my lord, the partition proceeds on the principle that you have an antecedent title. So, my lord, this is well established. I'll just show one judgment on this. So, you are seeking a declaration of title. Now, you must, when you seek partition, it must be presumed by the court that you are already a co-sharer. So, what are you asking for is severance.
No, if the plaintiff has prayed for a declaration, if the declaration is granted, yes, he is having a right, then automatically the partition will
No, my lord, yes. So, so it has to be declared that whether he has a right or not.
Correct.
So, the moment you claim that, it fails to be a partition suit. I'll tell you, lordship, why. Kindly have a look at the next prayers. Because prayer A is dependent on prayer B to E.
Okay.
Because unless he gets prayer B to E, he cannot get the declaration in respect of the ownership of the companies, businesses, the assets and properties. Because the companies, the assets and properties are all owned by the companies.
Yes.
So that is why the prayer is couched in a form to say that, my lord, he needs a declaration in respect of that. Now, my lord, kindly take prayer B.
Yes, you are argued that
Decree for
barred by 431.
My lord?
You on the last occasion you argued that it is barred by 431.
430, yes. No, I'm not on 430, my lord. Before 430, my lord, kindly take B. A decree declaration declaring that the alteration in respect of the shareholder pattern. So there has been an alteration in the shareholder pattern, and as also the directorial pattern and composition of the defendant number 8 to 14 are without authority.
And binding upon the.
So that means he accepts the position that there has been alteration in the shareholding structure and the director. So the shareholding structure, director, he wants a declaration to the extent that they are without authority.
Yes.
So now he has to first get B, then, my lord, kindly see C. declaration that irrespective of shareholding and directorial pattern and or composition of 8 to 15, the properties, businesses, assets of the company's firm, including those, are joint amongst the plaintiff and defendant number 1 and 2. How can it be joint? Unless you get B, the question of C does not arise. Because you are saying that today you are not the shareholder of any, you are saying, seeking a declaration that the change in the composition of the shareholding and directorship has to be declared by the court. So only thereafter the question of your prayer A will come. Well, also kindly see D and E. Mandatory injunction directing the defendants to restore the original shareholding pattern. Well, this can only be done under Section 59 of the Companies Act. It's an exclusive jurisdiction of the company tribunal.
Yes.
Decree for mandatory injunction passed directing the defendant number such and such to disclose full particulars of various movable, including jewelry. Then, my lord, kindly take preliminary decree. So, my lord, to get a decree, preliminary decree for partition, you must have what? To start with, a interest in the property. Now, you cannot seek a declaration, then you have to file a regular suit, get your title declared, and then file a partition suit. So, if you are not a co-sharer,
No.
having an existing share,
With respect to title, first the court has to decide in the preliminary form with regard to the title.
when will your lordship decide that? If today I come and say that I am not a co-sharer, I don't have a that is your praise.
That's why you're asking for the declaration. I am the co-share. He wants his declaration.
He cannot get a declaration in a partition suit. That's my respectful submission. Then the suit is barred. The moment you seek a declaration and then partition, that suit is barred. So you cannot ask for declaration of your own title and then file a partition suit. Now, kindly come to the judgment straight away. Well, kindly take. Well, I wish to rely upon a judgment. Well, 2004, Volume 3, Supreme Court Cases, page 376. Well, this is the unique situation in a partition suit. 376. Partition suit proceeds. It's a sine qua non that you must have an existing right. Unless you have that, the question of pursuing a partition suit, or you don't even have a right to sue, as we say.
So who will declare the right?
No.
Who will declare the
Not in a partition suit. Then you file a regular suit, seek a declaration that I have title to this property.
Then go to the partition.
And then partition. Well, otherwise you cannot have both in a partition suit. Unless you have a right. Now you come for what? The law is that when you have a right, when you file partition, what happens?
Suppose I am claiming X land, and I find that X land has been sold by B.
Correct.
To C.
Right.
But I am telling that property I am having the right. It was my grandfather or my father's property.
Right.
So first I will what was my prayer? First declaration the deed null and void. Declaration the title, I am having a right and title, then the preliminary decree. Thereafter the partition in terms of the preliminary decree.
Final decree.
As per as the law, but I don't, let me see the law.
Yes. Well,
As per
now,
the law, this is the provisions.
No, then what will happen is, two multifariousness will happen. What just fell from your lordship, it will become a suit which will be hit by the principles of multifariousness.
I don't think.
Because, kindly, allow me to, I'll make an endeavor to, substantiate this part. A partition suit is unique in its nature.
Correct.
Unlike other suits, that means you have a joint interest in a property. Your joint interest, if it is disputed, like suppose I say that, like your lordship said, grandfather, say 2 sons and 2 daughters. And all along continued, I am, say, one of the daughter or a son of, say, a sister or a daughter, son of one of the daughters. I say that one of the property is being sought to be sold since it belongs to the Mitakshari school of Hindu law, I have an undivided share
Or the property.
by operation of law. Because it is Mitakshari school of Hindu law, by operation of law, say I have 1/10 share or whatever. So I file a partition suit seeking a declaration of title. That means what? Not that the court will ascertain whether you have a you have a title to the property. No. Court will proceed on the basis, if it is a partition suit, that you have a right. Now, how much of right, that the court will decide, 1/10 or 1/8, then it will become severance. It will be severed.
Correct.
1/10, 1/4,
Correct.
half, 1/3.
That is the preliminary.
That is the issue.
That
Now,
is preliminary. Subsequently, the partition.
final, that is by meets and bounds.
Correct.
So, what I am respectfully submitting is that a suit of this nature, well, there cannot be a partition when you are saying that I don't have interest. You give me a declaration that I have title, then you give me partition. That is not permissible.
Okay.
Now, my lord, kindly take this. Your lordship can consider the facts at the first paragraph itself, from where your lordship will be able to find that what was the nature of the suit, which was the subject matter of, eventually went before the Supreme Court. And then, my lord, kindly come to para 6. It's a short judgment. My lord, kindly take para 6. At this stage, para 6. Yes. At this stage, it is important to bear in mind that partition is really a process by which a joint enjoyment of the property is transformed into an enjoyment severally.
Correct.
So that severance happens. In the case of partition, each co-sharer has an antecedent title.
Correct.
And therefore, no conferment of a new title. See Mullah's Transfer of Property Act, 9th edition, page 77. Well, I could not locate the 9th edition, but I have a 17th edition and the subsequent edition. If your lordship wants, I'll get it. Possibly it is there in the judge's library, the 7th edition, the 9th edition. In the circumstances, the appellants cannot be heard to say that they became the owners of the property only when the partition deed was executed on such and such. So, my lord, what he is trying to say, through this suit, he'll establish his title and then get partition. Your suit is barred, because barred in the sense that you don't have a right to sue. So, my lord, here the principle is that, my lord, antecedent title means a pre-existing right that a party has in a property. So, unless you have a pre-existing right, partition is not permissible.
So, who decide?
No.
The court has to decide.
Go file a suit. Go file a regular suit. Go file a regular suit. Get that. If that suit succeeds, then you have a partition. So, what I am respectfully submitting is that this joinder in a partition suit is not permissible in law. You have, nobody says that you cannot file a suit to establish your title. Tomorrow I might go and file a suit that my grandfather was the owner of Victoria Memorial. So I have a right. So before I seek the partition of Victoria Memorial, I must have to first go to a civil court, establish it, that I have a title. Once you develop that, yes, you have some right in the title, come partition suit. My lord, otherwise, my lord, the very concept of partition suit will stand defeated.
Okay.
So this is my first submission, my lord. He has not made out a case of antecedent title to any of the properties. Because why? Because he says, because his averments in the plaint, your lordship will find, he has accepted the position that the severance had already taken place. It was adjoined. 2011 partition happened, everything severed. So it came to an end. That is why he seeks a declaration of his title and then partition. Not permissible in law. Okay. Now, my lord, I'll just show your lordship.
only asked for
Now, my lord, kindly once take para 21 of the plain.
Yes.
Well, the fact that the said properties, businesses, and assets were joined between the plaintiff and the defendant number 1 and 2 were and or are not in dispute
Till 2011.
until, your lordship will kindly make a note of this word,
Yes.
until 2011.
Yes.
Well, this is where my point of limitation starts. Your lordship will make a note that the suit was filed in 2022. Then, however, taking advantage of the commanding position, the defendant number 2, by way of chartered accountant, by being a chartered accountant and being blindfoldedly trusted by the plaintiff, and for the fact that the registered office of most of the defendant companies were situated in Kolkata, when it was located, defendant number 2 was in concert and collusion with defendant number 1, has altered the position and is now alleging that some of the company properties, assets, businesses are not joint. Then, my lord, it is thus clear that the company properties, then, my lord, kindly see some of the paragraphs which are relevant for limitation. Para 29. My lord, also, my lord, kindly have a look at para 24. These are all, my lord, to substantiate, my lord, my contention that the suit is expressly barred by limitation. My lord, kindly take first para 24 before I take your lordship to 29. During the lifetime of Radhesham Gupta, my lord, this is the original patriarch of the family, had purchased 6 factory such and such. The said property was purchased in auction. Apart from the machinery such and such, the said property was registered as such and such in the name of this name of a company, D12. In the year 2008, the defendant number 2 entered into a development agreement, 5 crore. Defendant was thus became liable to make over the third portion of such amount to the plaintiff. Lordship will see in the time. Now, my lord, kindly turn to 29. Defendant number 1 and 2 is seeking to deny the plaintiff's lawful share in the joint companies, properties, businesses, assets, frivolous, baseless ground, and contending that the defendant number 8 to 15 are juristic entities and cannot be the subject matter of joint properties and cannot be subject to partition. The defendant number 1 and 2 are also legally contending that the independent right, title, and interest in the family members of the same companies, this is our contention according to them, businesses, properties, assets, which are in fact jointly owned by the plaintiff and the defendant number 1 and 2. In addition thereto, the defendant number 1 and 2 are taking shelter of an advice of mediator, namely such and such, which has communicated to the parties by way of an email of 24th November 2012, which is not at all binding upon the plaintiff. Thus, the question of acting in terms of the email of the plaintiff does not and cannot arise. So, this email that he is referring to is actually the partition that had already happened, which he says is not binding. So, well, from 2012, it is not binding. It is not. It did not start binding. Well, when you filed the suit. Now, my lord, kindly apropos this, take a letter which was written prior to the filing of the suit. Yes, well, this is a part of the plaint. The suit is based on this letter. Now, my lord, kindly take, I don't know, my lord, there's no pagination in the,
page 46.
possibly, my lord, subject to correction, it could be page 46 or 49. Your lordship will see there's a letter of an advocate, Priyanka Mukherjee, dated 13th of May 2022.
Yes.
Yes, my lord. Just a few paragraphs from this letter. My lord, allegation is misappropriation of fund. This is the subject.
Internal page 3.
My lord, kindly see. My lord, kindly the last sentence, the second last paragraph of page, the first page of the letter, that during the lifetime of such and such, he also from several other closely held family companies, which are, these are the name of the companies. Then, my lord, kindly take the third paragraph thereafter, that in the year 2000, another company was formed. Then, my lord, kindly come to internal page 3, the second paragraph from the top. That from the year 2008, that from the year 2008 onwards, you, the addressee number 1 and 3, in collusion and connivance with the addressee number 2 and 4 fraudulently. So, well, this, according to the plaintiff, their own letter issued in 2002, this alleged collusion, connivance, fraud, transfer, everything commenced in the cause of action accrued in 2008. So, your right to sue accrued at best, according to you, only in 2008. Transferred such and such shares of my clients amounting to several crores without the knowledge and consent. Then, that the aforesaid such and such shares have been transferred by forging the signatures of my client. Then, later my clients questioned about the doubtful activities and non-transparency, removed the directorship. Then, my lord, next paragraph. Again, fraudulent transfer of shares of my client. Then the paragraph thereafter. It is pertinent to mention that after illegally removing my client from the directorship of the companies, all of you fraudulently transferred all the shares of the companies, namely such and such. These are the defendant companies, my lord. Subsequently amalgamated these 3 companies. My lord, it is also, my lord, this amalgamation can only happen under section 391 of the Companies Act. Then, my lord, it is pertinent to mention that illegal removal of my client from the directorship, fraudulently transfer. Again, my lord, subsequently converted this company into private limited to LLP. Then, it is pertinent to mention that during the lifetime of deceased Radhesham, Gupta had created a HUF in the name such and such. My lord, he has now been the Karta and invested huge funds in such and such. Thereafter, my lord, the misappropriation of funds. My lord, then your lordship will see there's an allegation of in the year 1995 trust.
Yes.
এটা আমার জায়গাটা blank আছে। Four, এটা 4, 3, 4. Now, my lord, kindly turn to the next page, which should be internal page 4 of the letter. And my lord, kindly come to the second last paragraph from the bottom. There's a sentence, there's a paragraph starting with that with object.
Yes.
To resolve the disputes as aforesaid, a family meeting of the successors of the deceased Radhesham Gupta was held. And one of the brother-in-laws, namely Saurav Jalan, expressed his willingness to take charge to act as mediator for the purpose of family settlement. And my client, on good faith, agreed to allow the said such and such to act as a mediator. Ultimately, sent a mail in 2012. Whereupon it appears that Saurav Jalan has not dealt with the property and companies belonging. So, my lord, kindly make a note of the last sentence, please.
Resolve the dispute as aforesaid. So he had knowledge.
This is Radhesham Gupta and his family has not acted impartially.
Now, my lord, if your lordship will allow me to place this paragraph, this is the paragraph. It starts this with that with object to resolve the disputes. What disputes? As aforesaid. So, as aforesaid, your lordship, I have placed all the entire allegations. A family meeting, then when 12. And what he says, wherefrom it appears that such and such has not dealt with the properties and the companies belonging to such and such and has not acted impartially. He did not act impartially. He acted partially. So your cause of action has already accrued in 2012. When he did not act partially while dealing with all your allegations in the present plaint. Then, my lord, that in the email, Saurav Jalan divided 5 companies amongst the addressee number 1. Has your lordship found that, my lord?
Yes.
So the division has already happened.
Yes.
And my client inter alia such and such has been provided to the addressee number 1. And the next 2 companies' name has been provided in favor of my client.
Yes.
Whereas one company by the name of Olympia Credit, along with its property at Dashnagar, Howrah, remains as joint. But surprisingly, he kept silent as regard to 7 other companies. So what happened? Let's proceed on the assumption, because at this stage, my lord, we proceed that the averments with plaint are true and correct. So this is a part of an annexure which has been disclosed by with you the plaint. Court can take judicial notice of that in exercise of powers under Order 7 Rule 11. So your right, if at all, was affected in 2012.
Yes.
Now, my lord, your lordship will see the subsequent paragraphs. It has further mentioned in the email that the individual family share
Yes.
is such and such, and rupees such and such lakhs will be remitted from Kolkata office to my client. That is the plaintiff. And rupees such and such lakh to the wife of Radhesham Gupta. And it further appears that Saurav Jalan allows the address of such and such to enjoy major benefits in respect of the cash flow, investment and property. Surprisingly, Saurav Jalan did not disclose how and where from he had determined the valuation which he had decided, and also failed to disclose which properties and other assets have been taken into consideration and their valuation. As such, the dispute is still subsisting. But the dispute started when? When Saurav Jalan was appointed as a mediator and he partitioned the joint family properties. You have said that in the previous paragraph, in the earlier paragraphs, and that you say that it was not acceptable to you. So your right to sue has started in the year 2012 when that exercise was undertaken. Then, my lord, on 9th of May 2021, the wife of deceased such and such, namely such and such, with PAN number also expired, and after expiry, the allocated alleged shares of such and such has been grabbed. No matter when was this grabbing happened, even according to the plaintiff, in November 2012, and removed all the movable assets, namely, this is not a case of continuing cause of action. This is not a money suit. Well, this is not a running and continuous account that I am paying, so your limitation keeps extending.
Yes.
Limitation, my lord, in my limited understanding, I'll show your lordship the relevant article. When the right to sue first accrues, then, my lord, kindly take, my lord, the subsequent paragraph. It is even more interesting. Kindly have a look at this, my lord. It is also very curious enough to note that you, the addressee number 3, operated HDFC bank account in Kolkata in the name of my clients, namely Manoj Gupta, and account number such and such in the name of Reena Gupta, and my daughters such and such, for forging the signatures and fraudulently removed the fund from the said account and also misutilized the account for illegal gains. So all done.
Yes.
So you're complaining after 10 years. It is also to be stated that you, the addressee number 1 and 3, are withholding all the necessary documents in regard to the aforesaid companies as well as the properties, including personal documents and files. And as such, my client reasonably suspect all of you are in collusion and connivance with each other and commit further fraud, with my client taking advantage of my client staying from far away from Calcutta. Under the aforesaid circumstances, all of you are hereby requested to provide detailed information regarding the aforesaid companies as well as the properties and to restore the shares of my clients and directorship in those companies, and also to provide the financial details of the HUF trust individual accounts of Radheshyam such and such to allow enter into the property situated at Ranchi. Grievance should be resolved within a fortnight, failing which suit.
Yes.
Now, my lord, kindly have a look at the Limitation Act once. ওইটা দাও Desh, my lord, kindly take part 3, my lord, article 58.
Yes.
My lord, kindly see the column which says when the period begins to run.
Yes.
My lord, when the right to sue first accrues.
Correct.
So, my lord, the word is, my lord, between sue and accrue,
Yes.
the word is first. It is not that just because my advocate has issued a notice in the year 2022,
Yes.
that gives rise to a cause of action for me to file a suit
Yes.
for partition, seeking declaration of my right and partition. So your rights or your right or your to sue first accrued, if not in 2008, but in definitely 2012.
Yes.
Whatever you're complaining of from para 1 to the last paragraph of the plaint and your relief that you claim, alleging that these are joint family properties. So this division has already happened in 12.
Yes.
Monies according to you were removed. You were removed from shareholders of different companies. You were removed as directors. My lord, the effect of the settlement that happened in 2012 was already given effect too.
Yes.
Bank account 3, your daughters, your wife's bank account funds were removed according to you in 2012. Now, my lord, apropos this, my lord, kindly have a look at one judgment of the Supreme Court. Limitation টা দেখ। 11টা আগে দেখাইছে। My lord, kindly take 2011 9 SCC page 126. দেয়নি কেন? আমার নেই কেন এটা? 2011 এই আছে আছে আছে। Khatri Hotels 11 9 SCC 126. But since I don't have much time, my lord, I'll straight away take your lordship to para 30. Mr. Sen has put me on a timeline, my lord. So I'll straight away take your lordship to para 30. My lord, before para 30, my lord, kindly make a note. Para 24.
Yes.
Hi, George appoint karo, Ministry of Law ke likho. Likho. My lord, everybody wants one judge to do everything. That becomes difficult. Well, today I mentioned the matter before one honorable judge. He said, "What do I do?" So I really had no answer. So it was an extremely urgent matter. So I had to also appreciate what the judge had to say. He said, "What do I do? When will I hear it?" He said, there are more than 1100 motions pending.
There's one option. As advocates, we have to argue a little less.
Then
On established proposition, We have to argue less.
My lord, if we stop filing frivolous suits, my lord, this will solve the problem from the root.
That has to be decided by the court only. Whether it's a
No, if it doesn't come, why will your lordship need to decide?
To get rid of a frivolous suit, he is requiring 6 months' time to impress upon the court that it is a frivolous suit.
No, why? My lord, again, frivolous suit. Now, my lord, kindly take, my lord, para 24. Here is the issue of limitation raised. 58, my lord, quoted in para 25. Now, my lord, kindly come to para 30 and 31.
Yes.
Yes. Now, my lord, kindly make a note of this, my lord. Only one thing, my lord. Previously, Article 50 was Article 120. My lord, the difference is noted in the pre. My lord, kindly make a note. It was previously, my lord, that the previous page, your lordship will see, when the right to sue accrues was there under Article 120 previously. Now, my lord, now under Article 58, the word first has been added between the words sue and accrue.
When the right to sue accrues,
This is what it was.
First has been added.
Correct. So the first has been added. This is what Supreme Court has to say now. The my lord, kindly take once para 27. The differences which are discernible from the language of the above reproduced two articles are, then it says, then my lord, the same view was reiterated in Ammalal, then my lord, Rukmani, then my lord, kindly take the quoted portion at para 33 of Rukmani Bai's case, which is 1960 Supreme Court. Then, my lord, kindly take, my lord, para 30. While enacting Article 58, the legislature designedly made a departure from the language of Article 120 of the 1908 Act. The word first has been used between the words sue and accrued. This would mean that if a suit is based on multiple cause of action, the period of limitation will begin to run from the date when the right to sue first accrues. To put it differently, successive violation of the right will not give rise to fresh cause, and the suit will be liable to be dismissed if it is beyond the period of limitation counted from the day when the right to sue first accrued. Now, my lord, my lord, 2020 7 SCC 7366. My lord, only one paragraph. 2027. তাড়াতাড়ি দাও। limitation হবে 28 টা দেখে দিই। Now, my lord, kindly one stake. My lord, one stake, because I am also relying upon this paragraph.
23.3
23, no, 23 point, my lord, just your lordship can make. I am relying upon 23.3. 23.6 in conjunction with documents. So, well, this gives you a complete it covers all my points.
23.8.
My lord, kindly take then 23.8.
23.30.
Then 23.13.
23.15. 24.
Then 24. Then 26. 58, 59. Both are quoted then, my lord. 58 is the point. My lord, para 27, kindly consider Khatri hotels have been followed. And then, my lord, kindly take 28.
Right to sue. Yes.
Yes.
My lord, kindly take placitum A. The three-judge bench in state of Punjab, which is Gurdev Singh, held that the court must examine the plaintiff and determine when the right to sue first accrued to the plaintiff. Well, the court must examine. The words right to sue means the right to seek relief by means of legal proceeding. The right to sue accrues only when the cause of action arises. The suit must be instituted when the right asserted in the right is infringed, or when there is a clear unequivocal threat to infringe such right. But his paragraphs and the letter makes it abundantly clear when his alleged rights were infringed, if at all. Then, my lord, 1918. So I am finished, madam. 1918. Well, this is on that company point. Your lordship will see entirety. None of the properties are remotely connected. And what he's trying to say, that's prayer B, C, D, E, squarely within the jurisdiction of the company court. So your lordship can make a note of this. Your lordship will kindly see this. That's 430 bar, read with 59. Eta holo tomar 1918 SCC 569. Khemka, Sashi Prakash Khemka. My lord, kindly take para 6 once. 2019, 2019, 18 SCC 569. Para 6. It is not in dispute that were a dispute to arise today, a civil suit remedy would be completely barred and the power would be vested with the National Company Document Number 59 of the Act. So in what perspective that your lordship will find in paragraph 3 and 4. Today court cannot. What he is trying to say, he is asking for alteration of the change of the shareholding structure of the company. So that would amount to rectification of the register, not possible. Exclusive domain 59 company tribunal. Yes. And then what is he talking about? He's technically, if your lordship will see, oppression and mismanagement action. Yes. You've removed me, you've done this. So these are all acts of mismanagement and oppression, if at all. So both 59 and his act of mismanagement, oppression 241, 240, all covered by 430. So this 430 would be also be a complete bar if your lordship otherwise. This is my alternative argument. Okay. Apart from that, these are my respectful submissions.
Thank you.
2022 ta dekhiye 2022 86. So my pep talk helped. Can I come back? The client is really very
and that's why Mr. Wu said what to do.
Ministry of Law.
Nothing. Learned counsel for the defendant has concluded his argument in connection with Learned counsel for the defendant concluded his argument in connection with GA 5 of 2023. Due to paucity of time, learned counsel for the plaintiff could not argue the matter. According case is adjourned. Let the matter appear on 25th.
Yes.
25th August. Time cannot be given. Non-commercial. Non-commercial.
Yes, this is non-commercial.
Then 22nd.
22nd, my lord, both of us may not be there.
Then 29th.
Well, we can do it on 25th.
25th and no, they can
29th, your lordship.
29th at 2 p.m. It will come in the 2 p.m. list.
But let it be fixed at 2 p.m. I will only take half an hour and finish it off.
2 p.m. the other matters at the top.
At the top.
Before your lordship rises.
Oh, my 29th, I am in Delhi. My 29th, I am not there.
You will not be available.
20.
Then 22, you will
29, my lord, I am not there.
5th is holiday now.
Well, let us do it on any other day, my lord, which is not a.
कोई time है कुछ देखो.
Virtually join करते हो ना?
28 তে করে দাও না 28 27
अगस्त में क्या है
ওই week any day
Any day in that week.
or any other day convenient to your lordship
सितंबर कब होएगा 12:30 15 सितंबर
very well
15, my lord, 9th to 17th, I will be.
September
Yes, 9 to 17, my lord, I have some personal difficulty. I may not be here.
18th
18th. is
18th at 18 September 12:30
very well great
তার আগে একটা কোনো হচ্ছে না মানে no date before that my lord
Malad, in one matter I have got a date after the puja vacation
অনেক হয়ে যেত item
so
number
Malad,
one.
you see
But I am
nobody
saying,
is ready
but
to say
can
that
we-
let the matter
can we
appear
take
in
a
the list in the regular
on
course
any date without any time
what
fix.
is the problem this is a commercial code now several matters has been assigned which is non-commercial so I commercial already I fixed my diary so non-commercial I fix a Friday and company has also been given here so I am taking a company on Wednesday non-commercial on Friday the other that is the problem otherwise I could have been all matters are fixed prior to
But
that
without time, if we can take a chance on any day,
without
very well.
come on that day it will be completed yes
Before your lordship rises, lordship, I apologize for mentioning at this hour, lordship.
Hmm.
Lordship, the very next matter, item number 8 of the commercial list. Today was our day to give a reply. Lordship, my senior is will be engaged in court number 4. Lordship, I'm praying for an accommodation today. Lordship, I'm praying that the matter be taken on any day on Tuesday or any day thereafter, subject to your lordship's convenience.
I'm being led by Mr. Ray.
Malad, I have finished my submissions, Malad. This is that matter, Malad, where Malad,
There's a
order
two-
9 rules. were taken.
come at 2 p.m. but let us see if the fixed matter will not be taken then I will see
Very well.
Grateful.
Yes.
But from the last deposition, I find that questions were asked as regards its affidavit, but it was not specifically tendered, not as an exhibit. May I just tender that?
In the
It on an affidavit to me. Affidavit. তাহলে আমি না থাক এমনি tender করব। May it be tendered as is evidence. Affidavit. Exhibit correction.
Yeah, already tendered.
Very well.
Yes.
Shown a document appearing at pages 80 and 81.
This is where I had to step in. I was prepared for this.
Huh?
This is the only document which he cannot rely upon.
What?
Because this is not disclosed with the plate. This is the additional document, new document. This email, my lord, which he wants to introduce today in evidence was not there in the plate. Okay. That's at page 80. Apart from that, every other document is there disclosed with the plate. And your lordship knows in commercial suit, my lord, he cannot.
Yes, it's all right.
The pages, I've been informed by my learned junior, pages 80 to 83 of the judge's brief of documents. These are the new documents. 82 and 83. No, 82. Oh, 80 to 83. 80 to 83.
At page 98 of the plaint.
Yes. Yes, page 98.
But what is the next Shraddha?
Must be referring to some other plaint.
Sorry, Mura. Plaint must be. Where is it? এই সুটের প্লেনটি দেখেছিলেন তো দেখেছেন এত এবল জুনিয়র
At page 80 and 81 of the judge's brief of documents being part of PD.
being part of PD কত
Being part of PD4. What is this document?
सर ये email है from Royal Built to our company Rayada Marbles.
From Royal Built. Royal Built Infrastructure, Private Limited, to our company Rayada Marbles.
Asking for quotation for marble, granite, quota stone, etc.
Quota stone, etc.
Can you please identify and indicate the email ID of the defendant that you are referring to?
हाँ जी ये स्वपन कुमार विश्वास from Royal Built Infrastructure.
Email ID.
Email ID yes royalbuiltinfra@gmail.com.
Royal Built Infra.
infra@gmail.com.
Please identify and indicate the email ID of the plaintiff.
Rajada.marbles@gmail.com.
Marbles. Yes, sir.
How did you retrieve the copy on this email?
कैसे मिला?
सर ये हमारे मेल आईडी पर आया हुआ था और वहीं से हमने इसको प्रिंट आउट लिया है हमारे ऑफिस कंप्यूटर से.
This email was sent to our email ID, and from there,
But may it only go as plaintiff's email ID?
This email came to our office email ID, and it was in the officer computer, and the same was downloaded from the said system.
Who has taken printout of this email?
सर हम लिए.
I have taken the print.
Sir, nahi, on my lord. Have you affirmed any affidavit with respect to this email
के लिए आपने कोई affidavit
under section 65B?
65B का कोई affidavit आपने sign किया?
हाँ साइन किया.
But may I have copy? Copy तो देते. But may this email be tendered in evidence and marked?
दे दूंगी.
Shown an affidavit. Is this the affidavit that you referred to in your previous answer?
हाँ जी.
It doesn't need to be tendered in evidence.
Not.
But may the email be marked in evidence center, tendered in evidence and marked.
वो दो affidavit.
It is active na top ko.
Which page? Page number?
But this is 81. 81 and 82 of the judge's brief. Serial number C at page 3.
3.
Yes, madam. Pages 58 to 87, it contains that.
Okay.
Those are series of emails, madam.
Exhibit A. Exhibit A. Email dated, recorder. Email dated 26 January 2025, 2015 at 1:34 p.m. is marked Exhibit A.
But along with the enclosure, that is also there.
Along with enclosure. Marked Exhibit A collectively कर दो फिर.
Shown a document appearing at pages 82 and 83 of the judge's brief, being part of PD. PD4. 80.
JPD.
What is this document?
दिस इज एन ईमेल जो हम लोगों ने 31 जनवरी को रॉयल बिल्ट इंफ्रास्ट्रक्चर को भेजा था. डेटेड 31 जनवरी 2015 at 1:16 p.m.
That we had sent to Royal Built Infrastructure Private Limited.
इसमें हम लोगों ने उनको जो कोटेशन उन्होंने मांगा था वो कोटेशन बना के दिया था.
In this, we have prepared the quotation that the defendant company had asked for.
Who has sent this email?
मैंने भेजा.
I have sent the email.
What do you have to say about the contents of this document?
Sir, true and correct, sir.
But may this email be tendered in evidence.
Email dated 31st January 2015 at 1:16 p.m. Exhibit B collectively.
Shown a document appearing at pages 1 to 3. 1 to 3 of the judge's brief as PD1. What is this document?
सर ये जब हम लोगों ने कोटेशन बना के भेजा था तो उसके रिप्लाई में उनका परचेज ऑर्डर हमारे पास आया था 3 नवंबर 2015 at 1:25 PM। हमारे रॉयल बिट इंफ्रास्ट्रक्चर मेल आईडी से हमारे मेल आईडी raida.marbles@gmail.com पर आया था।
This email is a reply from Royal Built Infrastructure Private Limited for the purchase order that we had sent them. This email is dated November 3rd, 2015 at 1:25 PM.
Kindly look at the email and tell the Honorable Court who is Mr. Shaurendra De.
शौरेंद्र दे रॉयल बिट इंफ्रास्ट्रक्चर के डायरेक्टर हैं।
The director of Royal Built Infrastructure.
Kindly look at the document enclosed to this email. Do you identify the signature appearing at page 3 of the judge's brief of documents? Third page, sir.
हाँ जी, मिस्टर शौरेंद्र दे ने साइन किया है।
Mr. Surendra De has signed this document.
How do you know the signature of Mr. Shaurendra De?
ये कई बार हमारे पास रेगुलर माल लेने आते जाते थे और साथ में सामने साइन किया है तो हमने देखा है इनको।
Several times,
मटेरियल्स
several times, Mr. Surendra De had visited our office for purchasing materials. Therefore, I know his signature.
How have you retrieved this email?
ट्रू एंड करेक्ट।
In the order of
मेल बाय मेल मिला है सर। ये हमने अपने ऑफिस कंप्यूटर से प्रिंट आउट लिया है।
This mail was downloaded from the email, from our email, and then printed from our office.
Who has taken printout of this email?
मैंने लिया।
I have taken.
May this be tendered in evidence and marked as exhibit.
Exhibit C collectively.
Shown a bunch of documents appearing at pages 4 to 6, no, 7, 4 to 7 of the judge's brief of document as being part of PD2. Please look at page 4 of the judge's brief. Now, please look at the document and tell what is this document?
सर ये जो मटेरियल गया उसके अगेंस्ट में टैक्स इनवॉइस रेज किया हुआ है।
This is the tax invoice raised against the materials that were supplied to
रॉयल बिल्ट इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड।
Who has prepared this tax invoice?
सर ये हमारा अकाउंटेंट प्रिपेयर किया है, मिस्टर स्वरूप अडक।
Mr. Swarup Adak, our accountant, had prepared this tax invoice.
Can you identify the signature appearing at bottom right of this tax invoice?
जी हाँ, उसका स्वरूप अडक का साइन है ये।
This is the signature of Swarup Adak.
Under whose instructions was this tax invoice prepared?
Yeah, this is
मेरे बोलने पर ये टैक्स इनवॉइस बना।
on my instruction.
What do you have to say about the contents of this document?
सर एकदम ट्रू एंड करेक्ट।
एकदम true and एकदम next page, PD5. Shown the document appearing at page 5 of the judge's brief. What is this document?
So this is a चालान सर जो टैक्स इनवॉइस के साथ जाता है।
This is a challan that we sent along with the tax invoice.
Who has prepared this document?
सर ये स्वरूप अडक नहीं बना है सर।
Under whose instructions was this document prepared?
सर मेरे इंस्ट्रक्शन पर बना है।
What do you have to say about the contents of this document?
सर सही है सर।
Shown page 6 of the judge's brief of documents. What is this document?
सर ये रोड चालान है जब मटेरियल
सर बोलिए
बोलिए बोलिए।
लॉर्ड सर ये रोड चालान है जो मटेरियल भेजते हैं उसके साथ भेजना पड़ता है।
This is the road challan that is sent along with the materials supplied.
What is the material that you are referring to?
सर कोटा स्टोन।
KOT, Kota stone.
Can you identify the signature and the stamp appearing at bottom left of this document?
जी हाँ, ये रॉयल बिल्ट इंफ्रास्ट्रक्चर का स्टाफ था देवाशीष घोष, उसने रिसीव किया था मटेरियल।
Devashish Ghosh, staff of Royal Built Infrastructure, had received the materials.
Who has prepared this document?
ये स्वरूप ने, माय अकाउंटेंट सर, अकाउंटेंट ने इसको प्रिपेयर किया।
Sir Swarup, Adak, my accountant, had prepared this document.
Under whose instructions?
मैंने गाइड किया था सर, मैंने
On my
बोला।
instruction.
Can you identify the signature appearing at
हाँ जी,
bottom right of this document?
अकाउंटेंट का साइन है स्वरूप अडक।
Yes, this is the signature of our accountant, Swarup Adak.
What do you have to say about the contents of this document?
सर सही है एकदम,
True and correct.
Do you find a stamp at the back of the road challan?
यस, हाँ है सर।
Who has stamped this?
सर ये जब मटेरियल साइट पर जाता है तो गेट पर गाड़ी की एंट्री होती है, वो स्टाम्प है सर।
When the material that is supplied reaches the site, at that time, the stamp is put on the entrance of the site. Time of entry.
Entrance of the site.
क्या बोला है? आंसर क्या लिखा है? Citizen. The stamp has been put when the materials entered into the gate at the site.
Contents बोले नहीं थे ना? Contents है
No.
What do you have to say about the contents of this document?
सर सही है।
True and correct.
Under whose instructions was this document prepared?
सर मेरे इंस्ट्रक्शन पर।
On my instruction.
चलिए बोलिए पढ़ो। How were the materials sent to the defendants?
सर ट्रक से जाता है मटेरियल।
By truck.
Whether the tax invoice was raised by the plaintiffs before or after the delivery of materials.
पहले या बाद में tax
नहीं,
invoice.
डिलीवरी के बाद टैक्स इनवॉइस रेज होता है सर।
After the delivery of the materials, tax invoices are raised. Yes, sir.
How was this invoice and challan sent to the defendants?
Tax invoice चालान कैसे आपने कहा? Well built.
सर उनके ऑफिस में हमारा स्टाफ लेकर जाता था, एक कॉपी उनको दे देता था, एक कॉपी लेके आया।
Our office staff used to go to their office and delivered it to them by hand and brought another copy after receipt.
After? After taking receipt on the same.
The document shown to you shown page 4 of the judge's brief of documents. Pratham document. Do you see the writing original buyers stroke sellers stroke extra copy? Which among these is the document that I have shown to you?
ये सेलर्स कॉपी है, बायर्स कॉपी उनके पास रह जाती है.
This is seller's copy, buyer's copy is with them.
May this document be tendered in evidence?
Exhibit, yeah. D collectively. Yes, next.
Shown bunch of documents appearing at pages 8 to 10, 8 to 11 of the judge's brief of documents being part of PT2. What is the document appearing at page 8 of the judge's brief of documents? First page to that.
सर ये टैक्स इनवॉइस है जो ग्रेनाइट भेजे थे उसके अगेंस्ट रेज किया गया था.
This is the tax invoice that we had raised against the supply of granite.
Who has prepared this document?
और हमारा स्टाफ अकाउंटेंट स्वरूप अडक.
Our staff accountant Swarup Adak.
Can you identify?
Adak.
Adak AD had prepared this document.
Under whose instructions?
Sir, under my instructions.
Can you identify the signature appearing at bottom right of this document?
Yes, sir. ये स्टाफ का साइन है स्वरूप अडक.
Our staff Swarup Adak.
What do you have to say about the contents of this document?
Sir, एकदम true and correct.
These documents are denied.
Undefended suit. Look,
They are an undefended suit, so
I will only have a right to cross-examine.
Okay.
I was only misguided by my junior that there are new documents which was introduced.
Okay.
Oh, that's okay.
Very sorry, Willard, for that.
No, it's okay.
Can you identify the signature and the stamp appearing on the bottom left of this document?
Yes, my lord, ये पिंटू पात्रा का साइन है और रॉयल बिल्ट इंफ्रास्ट्रक्चर का स्टाम्प है.
Pintu Patra and the stamp is of Royal Built Infrastructure Private Limited. Infrastructure.
Royal Built Infrastructure Private Limited.
Who has prepared document?
Yes, it has come.
It was in respect of the previous question, madam.
No, 8. Page 8 to.
Okay. What do you have to say about the contents of this document?
Sir, it's true and correct, sir.
अच्छा लो ये आगे आंसर टा किधर
स्टाफ नहीं है, डायरेक्टर है. पिंटू पात्रो डायरेक्टर है, स्टाफ नहीं है.
How do you know the signature of Mr. Pintu Patro?
सर, इनसे हमारा बहुत दिन से काम होता है. ये बहुत बार ऑफिस आए हैं और हमारे सामने कई बार साइन करने का काम पड़ा, तो आई कैन रिकॉग्नाइज इट.
We had business relationship with him. He visited our office several times. Therefore, I know his.
No, he signed several documents in my presence.
In my presence. Therefore, in my presence. Therefore, I know this.
Thus, I identify the signature.
page 9, next page. What is the document appearing at page 9 of the judge's brief of documents?
सर ये चालान है which is raised against the invoice.
The challan raised against the tax
invoice.
Who has prepared this document?
Sir, my accountant, Mr. Swarup Badak, has prepared it.
Under whose instructions?
Under my instructions.
Can you identify the signature appearing at bottom right of this document?
Yes, I can identify. It's Swarup Badak.
Can you identify the signature and the stamp appearing at bottom left of this document?
हाँ जी, ये पिंटू पात्रा का साइन है सर, रॉयल बिल्ट इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड.
What do you have to say about the contents of this document?
Sir, true and correct, sir.
What is the document appearing at page 10 of the affidavit or judge's brief of documents?
सर ये रोड चालान है जो मटेरियल के साथ भेजना पड़ता है.
The road challan which is sent along with the materials.
Who has prepared this document?
सर हमारा दूसरा स्टाफ है कपिल जोशी, उसने प्रिपेयर किया.
Or another staff, Kapil
my lord,
Joshi has prepared this document.
Can you identify the no, sorry, under whose instructions?
Under my instruction.
Can you identify the signature appearing at bottom right of this document?
Yes, I can identify. ये कपिल जोशी का साइन है.
At the back of the road challan, you will find a stamp and inscriptions. Who has made this?
माय लॉर्ड, ये साइट पर एंट्री करते हो गेट एंट्री का स्टाम्प है. मटेरियल जब जाता है तो गेट एंट्री स्टाम्प साइन करते हैं.
The stamp put at the gate entry when the materials enter the site.
Which site are you referring to?
सर ये एगरा में मल्टी सुपर स्पेशलिटी हॉस्पिटल बना था गवर्नमेंट के द्वारा, उसमें ये माल गया था.
At Agra, a multi super specialty hospital had been built by the government. In that site, this had been taken.
What do you have to say about the contents of the document appearing at page 10 of the judge's brief of documents?
That's true and correct, sir.
Is the invoice appearing at page 8 the original copy or the seller's copy?
Sir, this is the seller's copy, sir.
Where is the original of the document appearing at pages 10 and 11 of the judge's brief of documents?
सर ओरिजिनल उनके रॉयल बिल्ट इंफ्रास्ट्रक्चर के ऑफिस में दिया जाता है.
The original of this document are the office of Royal Built Infrastructure Private Limited.
Xerox though. This Xerox though. ওইটা কি Xerox?
और
ওইটা না লাস্ট পেজটা দেখাচ্ছিলাম.
Yes.
10 and 11 দেখাচ্ছিলাম আগেরটা না. অ্যানসারটা কি কোনটা দেখিয়ে গেছে? সেকেন্ডটা দেখিয়ে গেছে না থার্ডটা? I was referring to the third document. The question, his question and his answer has gone as regards the second document. So, if that can be changed, because it's
You are not shown this handwritten.
Yes.
Page number 10. That is the road challan hai na? Page
Yes.
number
Page number, this is 10.
10 আপনি ওটাই দেখেছিলেন তো?
হ্যাঁ
এখন যে প্রশ্নটা করলেন এটা তো না এটা দেখো
হ্যাঁ সেটাই it was the second document was
last question.
which is a counter copy, but the third is a Xerox copy. The original is not there. So that is why I'm asking the
which
question.
one?
Look, 10 and 11.
Yes. Yes.
So his answer has got according to the question, second document. So may it be, I leave it to Lakshman.
No, this is not the answer.
That I cannot say. But what has
No.
happened?
जो 10 और 11 है ना
10 और 11
Yes, but his answer has gone because what was shown is the second document.
ऊपर कर दो 8 and 9. 8 and 9.
Very well. I'll ask another question about
8
10
and
and
9.
11.
question number.
So 8 and 9 is not the original.
Yes,
8 and 9 is original. That's why he's answered. But I had asked the question regarding 10 and 11, which is a Xerox copy.
ठीक है 10 कर दो 8 and 9 10 ही करो.
Okay.
Yes, next. Next.
Where is the original of the document appearing at page 10 and 11 of the judge's brief of documents? Original or counter copy?
सर ये कॉपी आई बिलीव मिसप्लेस हो गया सर, ये मिसप्लेस हो गया. Original.
I believe the copy of this road challan
Original copy.
original copy of this road challan has been misplaced.
Where did you then get the copy, Xerox copy of this document?
सर ये हमारे ऑडिटर्स को भेजना पड़ता है बिल और ये कॉपी, उनके वहां से मैंने ये चालान का जेरॉक्स कॉपी लिया.
This has been obtained from my auditor's copy where we used to send to the auditors.
It contains that. Other question, active question. Active.
Yes, next.
Yes, please. Where is the original of the वो seller's copy এটা বলেছেন already?
Yes,
May
next.
these three documents be tendered in evidence.
Exhibit E collectively.
No. The original. Shown a bunch of documents appearing at pages 12 to 15. 12 to 14. 12 to 14 of the judge's brief of documents. Can I note it backside? No. Which is that one? नहीं. What is the document appearing at page 12 of the affidavit of the judge's brief of documents?
माय लॉर्ड ये ग्रेनाइट गया था, उसके अगेंस्ट टैक्स इनवॉइस रेज किया, उसकी कॉपी.
This is the tax invoice raised against the supply of granite.
To whom was the granite supplied to?
सर रॉयल बिल्ट इंफ्रास्ट्रक्चर को सप्लाई किया था.
Royal Infrastructure Limited.
Who has prepared this document?
Sir, my lord, my staff, Mr. Swarup Adak, has prepared this document.
Under whose instructions?
Sir, under my instruction.
Can you identify the signature appearing at bottom right of this document?
हाँ जी, ये मेरे स्टाफ का साइन है. स्वरूप अडक.
What do you have to say about the contents of this document?
Sir, true and correct, sir.
Can you identify the signature and the stamp appearing at bottom left of this document?
हाँ सर, माय लॉर्ड ये पिंटू पात्रा का साइन है और उनकी कंपनी का स्टाम्प है.
Signature of Pintu Patra and stamp of his company.
Whether this is the original or the seller's copy?
सर ये सेलर्स कॉपी है.
This is seller's copy.
Where is the original of this document?
ओरिजिनल कॉपी माय लॉर्ड रॉयल बिल्ड इंफ्रास्ट्रक्चर के पास.
Is with Royal Built Infrastructure.
How was this invoice sent to the defendants?
माय लॉर्ड ये मेरा स्टाफ उनके ऑफिस में लेके गया था.
Our staff had taken this document to their office.
Page 13. That is why. Can you identify the document appearing at page 13 of the judge's brief of documents?
हाँ, ये चालान की कॉपी है जो टैक्स इनवॉइस के अगेंस्ट रेज किया गया.
The copy of challan that was raised against the tax invoice.
Who has prepared this challan?
My lord, my staff Swarup Adak has prepared this challan.
Whose signature appears on the bottom right of this document?
My lord, ये अकाउंटेंट का साइन है, स्वरूप अडक.
Under whose instructions was this challan prepared?
Under my instruction, my lord.
Can you identify the signature and the stamp appearing at bottom left of this document?
Yes, my lord. ये पिंटू पात्रा का साइन है और उसके कंपनी का स्टाम्प.
Stamp of his company.
What do you have to say about the contents of this document?
Sir, true and correct, sir.
Can you identify the document appearing at page 14 of the judge's brief of documents?
हाँ, ये रोड चालान है सर. ग्रेनाइट गया था, उसका रोड चालान.
Granites were supplied and road challan was raised.
Who has prepared this road challan?
ये स्वरूप अडक ने ही प्रिपेयर किया.
Swarup Adak had prepared this road challan.
Under whose instructions was this document prepared?
My instructions.
What do you have to say about the contents of this document?
Sir, एकदम true and correct, sir.
Can you identify the signature and the stamp appearing at bottom right of this document?
Yes, my lord. ये देवाशीष घोष का साइन है जो साइट पर उस वक्त प्रेजेंट था.
The signature of Devashish Ghosh, who was present at the site. And that
Which site are you referring to?
site.
एग्रा में मल्टी सुपर स्पेशलिटी हॉस्पिटल बन रहा था, वहां पे ये मटेरियल गया था. ये वो साइट का.
At Agra, one multi super specialty hospital had been built, and that was the site I am referring to. That is the site I am referring to.
Can you identify the document appearing at page 15? Oh, 14. Sorry.
Yes.
No, contents wise. It made these documents, the bunch of documents be tendered in evidence.
Exhibit F. Collectively. You do all the challenge, give it because all are
Very well.
How many
The only
challenge are
difficulty is in only 2 more documents are in Xerox, so I have to ask specific questions against them. Now I'll tender all of them together and then I'll identify those and ask separately. Shown the documents appearing at pages 15 to 56 of the judge's brief of documents being part of PD2. What are these documents?
सर ये टैक्स इनवॉइस है जो मटेरियल के अगेंस्ट रेज किया गया था.
Is the tax invoice raised against the materials that were supplied?
That was supplied from Rajada Marbles to Royal Built Infrastructure Private Limited. और ये हमारे स्टाफ स्वरूप अडक ने प्रिपेयर किया है जिसको पिंटू पात्रा ने रिसीव किया है.
This was prepared by our staff, Swarup Adak, and received by Pintu
Patra
of Royal
Built
Built
Infrastructure.
Infrastructure.
The only difficulty would be that if the witness can step out also, and just indicate that not every document may have the receiving signature of the same person. That.
Okay.
But I cannot guide him what to answer. That is the difficulty. He's only looked at the first document and answered.
आप पे जितना डॉक्यूमेंट है वो देखिए, उसमें क्या क्या डॉक्यूमेंट है बताइए.
Grateful.
पूरा पूरा बंच है ना आपको दिए?
हाँ.
15 से लेके 56 तक का.
हाँ जी.
उसमें आप बताइए कि इसमें क्या क्या डॉक्यूमेंट है.
माय लॉर्ड ये पूरा बंच के अंदर में टैक्स इनवॉइस, चालान और रोड चालान का कॉपी है.
Okay. This all documents contains tax invoices, challan, and road
चालान.
Who has prepared these documents?
सर मेरा माय लॉर्ड माय अकाउंटेंट स्वरूप अडक हैज prepared
all documents. All documents have been prepared by my accountant Swarup Adak.
Under whose instructions?
मेरे कहने पर किया था. माय इंस्ट्रक्शन.
Yes.
Are these the seller's copy or the buyer's copy?
सर ये सब
The invoices. Are the invoices buyer's copy or seller's copy?
सर ये सब सेलर्स कॉपी.
All are seller's copy.
Where is the original buyer's copy?
ओरिजिनल बायर्स कॉपी सब रॉयल बिल्ट इंफ्रास्ट्रक्चर के पास है.
Original buyer's copy is with Royal Built Infrastructure Private Limited.
How was the invoices and the other documents sent to the defendants?
बाय माय स्टाफ. मेरा स्टाफ लेके गया था उनके ऑफिस में.
My staff had taken the documents to their office.
Can you identify now whether do you find any stamp or signature of the defendants in any of these documents?
Some documents में
Defendant or its officers in this document?
के ऑफिसर या उनका कोई स्टैम्प आपको दिख रहा है?
हाँ जी दिख रहा है. इनवॉइस के लेफ्ट साइड पर है उनका.
Yes. on the left side of the invoice, I find
Received copy of the tax invoices. Yes.
Do you also find any signature or stamp on the challans, road challan and the road challans of the defendant audit officers?
हाँ my lord, उनका stamp और sign है.
yes, their sign and stamp is there. Yes.
Yes. Next.
And do you identify the same?
हाँ जी, पहचानता हूँ.
Yes, I can identify.
41, 42. Shown the documents appearing at pages 40, 41, 44, and 45 of the judge's brief of documents.
40, 41,
44
45.
and 45, these are Xerox copies. No, that's just 45.
44 or 45.
The contents were low. Proper document is contents.
Yes.
Yes. Where are the original of these documents?
Sir, original misplaced हो गया sir.
My originals are misplaced.
How did you get the photocopies of these documents?
सर वो हमारे ऑडिटर्स के पास हम लोगों को भेजना पड़ता है, तो उन्हीं से मैंने कॉपी वापस ली.
I have obtained these copies from our auditors as we had to send them copies.
So
Yes. Next.
under whose instructions were the documents appearing at page 15 to 56 were prepared?
Under my instruction.
What do you have to say about the contents of the said documents?
Sir, overall true and correct. Sir.
But may this be collectively?
Exhibit G. G collectively.
Collective. 56 होती होएगा लगता.
Yes. Next.
Shown a document appearing at page 57 of the judge's brief of documents. What is this document?
Tag कर दो, उसको tag कर दो.
सर ये एक्सेल शीट में हमने लेजर बनाकर रॉयल बिल्ट इंफ्रास्ट्रक्चर को भेजा था.
This is a ledger prepared in Excel sheet, and this sheet was sent by us to Royal Built Infrastructure Trust.
My lord. Certainly. Who has prepared this ledger?
My lord, मैंने खुद प्रिपेयर किया है.
I myself had prepared this ledger.
On what basis have you prepared this ledger?
माय लॉर्ड, जो मटेरियल्स उनको गया है और उसके अगेंस्ट जो पेमेंट हमने रिसीव किया है, वो सारे को टैली करने के बाद.
किस बेसिस में बनाया है, कहाँ से टैली किया हूँ, आपका वकील का पूछना हुआ है.
मेरे कंप्यूटर पर पूरा डेटा है, जब जब मटेरियल गया है और जब जब उन्होंने पेमेंट किया.
Data available in my computer with regard to the dispatch and receipt of the materials. On the basis of that, I have prepared.
And payment is also.
And the payment received. On the basis of the same, this has been prepared.
What do you have to say about the contents of this document?
Sir, true and correct, sir.
How was this document prepared?
My lord, on my computer, I have prepared this document. Office computer.
Who has taken printout of this document?
My lord, I have taken this printout.
Have you affirmed any affidavit in respect of this document?
Yes.
I'm not referring to it. It's already there. He has already identified that. It made this document be tendered in evidence and marked.
G. H. Next.
Contents. Contents.
Yes, it has come.
Shown the document appearing at page 58. No, it's 87. No, 87.
Page
No, only 87.
87.
87.
Yes.
What is this document?
माय लॉर्ड ये लेटर है जो रॉयल बिल्ट इंफ्रास्ट्रक्चर की तरफ से हमारे पास आया था रायदा मार्बल्स में। उसमें इन्होंने लिखा था कि जो लेटर हमने भेजा था आस्किंग फॉर आउटस्टैंडिंग ड्यू अमाउंट, उसके अगेंस्ट उन्होंने लेटर लिख के भेजा था कि हम लोग थोड़े टाइम के अंदर में पेमेंट कर दें।
This is the reply received from the defendant Royal Built Infrastructure Private Limited, wherein the defendant stated that they will clear the dues amount within some time.
Can you identify the signature and the stamp appearing at bottom left of this document?
यस माय लॉर्ड, ये पिंटू पात्रा का साइन है।
How do you know the signature of Mr. Pintu Patra?
सर पिंटू पात्रा पहले भी हमारे ऑफिस में बहुत बार आ चुके हैं और हमारे साथ कई बार काम हुआ, मेरे सामने कई बार साइन किया उन्होंने।
Earlier also, Pintu Patra had several times visited our office and he had signed in front of me. Therefore, I can identify the signature.
How did the plaintiffs receive this document?
सर ये बाय स्पीड पोस्ट भी आया था और बाय मेल भी आया था।
This letter was sent to us by speed post and also by email.
Shown the document may that be tendered in evidence.
Exhibit I.
Shown the document appearing at 86 था ना 58 था 58. May I refer to the judge's brief? This is a copy of the document. Shown page 58 of the judge's brief of document. What is this document?
सर ये वही लेटर है जो उन्होंने रॉयल बिल्ड इंफ्रास्ट्रक्चर ने रायदा मार्बल को भेजा था।
This is the same letter that Royal Built Infrastructure had sent to Raijada Marbles.
Is this the same letter that you have referred to in your answer to question number?
Previous question.
Previous question.
यस माय लॉर्ड, सेम लेटर है।
How have you received this
लॉर्ड
document?
ये बाय मेल आया था और बाय कॉपी भी आया था, हार्ड कॉपी भी आया था।
This letter was
But, may this also be tendered as the same exhibit by you? Yes, next.
I'll object. Not that's why. Not necessary, because you come to the page 87. Page 87. Earlier was the page 86, na? You are
87.
87. 87.
87. Now you see the page 86. That is the mail. You left that.
87 is the document.
86.
Yes, yes. I'll tender it together.
That should have been along with this.
Along with page 58.
50.
Yes. I'll ask this a question regarding this email, then it's a little haphazardly placed. The documents are a little haphazardly arranged in the. ওটা এখন tender করবেন না. Shown page 86 of the judge's brief of documents. What do you have to say about What is this document?
सर ये माय लॉर्ड ये मेल आया था रॉयल बिट इंफ्रास्ट्रक्चर से रायदा मार्बल्स को नवंबर 27, 2018 को at 10:13 p.m.
This mail was received by
This is the mail sent by the defendant to the plaintiff at 10:30 p.m.
10:13 p.m. sir.
10:13 p.m.
November 27th, 2018.
Do you find an enclosure to this email?
हाँ इसमें माय लॉर्ड इसमें एक अटैचमेंट है जो लेटर है जो
Yes, there is an attachment to this email.
The email contains the attachment of the letter dated 27/11/2018. Next.
Appearing at, because there are the same, one is signed, one is
appearing at page number
58 of the judge's preferred documents.
हाँ same letter है my lord.
Yes,
next.
But may this now be tendered in evidence?
Email करी दें.
Email dated 27th of November 2018, sent at 10:13 p.m.
Be marked as exhibit.
along with
the
attachment appearing at page 58 of the judge's brief of documents, tendered in evidence and marked as.
Yes, next.
Yes.
J collectively होगा.
Kunta. 59. Shown the documents appearing at page 59 and 60 of the judge's brief of documents. What is this document? Appearing at page 59.
माय लॉर्ड ये हम लोगों ने उनको आउटस्टैंडिंग अमाउंट कितना कितना दिन का बाकी है ये बना के भेजा था बाय ईमेल एंड बाय स्पीड पोस्ट आल्सो.
This is a letter that we have sent to Royal Built Infrastructure for their outstanding due
इसका साथ ना
with our company.
पेज 58 है ना, मुझे कॉपी दिया था जिसको वो नहीं किया था.
Who has prepared this document?
ये है.
सर हम
ये तो ये वाला है 50.
माय लॉर्ड आई हैव प्रिपेयर्ड दिस डॉक्यूमेंट. My lord, I have prepared this document.
Whose signature appears at bottom left of this document?
My lord, ये मेरा साइन है दीपक राय ज्यादा.
This is my sign.
What are the documents appearing at page 60 of the judge's brief of documents?
सर नीचे में जो हम लोगों ने माय लॉर्ड ये रिसीट है जो स्पीड पोस्ट से भेजा था और ऊपर में जब रॉयल बिल्ड इंफ्रास्ट्रक्चर ने लेटर रिसीव कर लिया था तो फिर हम पोस्ट ऑफिस से ही हम लोग रिसीव कर लिए उनका साइन कि उन्होंने रिसीव कर लिया.
Bottom of page number 60, this is the postal receipt, and above it is the acknowledgement slip.
What do you have to say about the contents of the document appearing at page 59?
True and correct, sir, my lord.
59.
Lord, may this be tendered in evidence, minute and mark.
क्या है बताओ.
Acknowledgement.
वो तो नीचे बनी जब card insert हो.
Acknowledgement.
The acknowledgement card. Lord, may I continue on the next?
Yeah, exhibit.
Exhibit K.
Okay. How many documents?
Lord, this is 60. There are 10 till 108, another 40 documents. But the emails, there are a series of similar emails. I'll try to do it together on the next occasion.
Okay. Come on the next. Plaintiff witness is present. During the examination of the plaintiff witness, documents were marked as exhibit A2, Exhibit K. Full stop. Due to paucity of time, examination in chief of the plaintiff witness could not be completed. Accordingly, chief is deferred. Let the matter appear on 27th October. First day of the second day. 27th October 2025 for further evidence, further examination in chief and cross examination of the plaintiff witness number 1
2 p.m.
at 2 p.m.
2 p.m. Deeply understood.
Next.
Appear for the defendant in the matter, man.
Yes.
I appear for the plaintiff. My PW2's examination is supposed to commence today. Malad, I'll just find the formal affidavit of evidence, prove that, and a few.
Yes.
Ask a few formal questions and then. তাড়াতাড়ি করুক না, just চেপে যাবে। Prepare as per my instruction. But this is not the entirety of the answer. So no. Okay. No. Ali, this is my prepared as my instruction.
Yes.
Okay. Big man.
Yes, first second PW2.
PW.
I.
Good afternoon, Mr. Milord.
Repeat after.
Tell your name. I. What is your name?
Repeat after him. He will administer the oath to you, and then you can repeat after him.
My name is Niladri Shah.
Now just repeat after him.
Okay.
I solemnly affirm that
in whatever I will depose
by way of
evidence
in this suit
I shall
speak the truth and no part of it shall be false and I shall not conceal anything. What is your name, sir?
Niladri Shah.
Father's name?
Nepal Chandra Shah. My age 51.
তাহলে ওটা আগে করে দিন। Are you trying to the printed তারপর document?
Yes.
ঠিক আছে, হ্যাঁ।
Sonarpur. Sonajil. Calcutta. 700150. Yes.
Mr. Shah, when you answer, kindly speak up so that my lord can hear clearly what you are saying.
Okay, sure.
And also speak slowly so that he can transcribe what you are saying.
Okay.
He cannot write as fast as you can speak. Okay. Okay. Mr. Shah, how are you connected with the plaintiff company?
I'm working with plaintiff company for last 15 years. I joined Vikram Solar 2010.
I joined Vikram Solar in 2010.
Yes.
Working since 15 years.
What is your current designation?
My lord, my designation is General Manager, Production Planning and Inventory Control.
And inventory control.
Control.
Just as authorization. I'm showing you a document. Kindly look into this document and tell my lord what this document is.
This is the board resolution copy of Vikram Solar dated 3rd December 2024.
Who has executed this document?
Mr. Sudipto Bhawal, the company secretary, has executed this document.
What does this document speak of?
This is the document is authorizing me for giving the evidence for Vikram Solar Limited.
Only one thing, I am not objecting to this. Can a copy be given to us?
Yeah, I'll give you a copy. I'll give him a copy.
It's a board resolution, right?
My lord, may it be tended.
Yes. Exhibit? Huh? Double O.
Yes. তারপরে দিয়ে দিই আর তার তো কিছু এখন জিজ্ঞেস করেনি এটা বলে দিয়েছে এখন পরমিশন চলে গেছে
Yes, next.
The evidence and affidavit. I'm showing you a document. Kindly look at this document and tell my lord what this document is.
This is, sir, affidavit of evidence affirmed by me, dated 13 February 2025, sir.
On whose instructions was this document prepared?
As per my instruction, my advocate has prepared this document, sir.
Are the statements made in this affidavit true and correct?
Yes, all the statement are true and correct.
It is the exhibit conclusion. বলেছে kindly repeat the date of affirmation of this affidavit.
13th February 2025.
ঠিক আছে আর কি জিজ্ঞেস করবে হ্যাঁ এটা ঠিক আছে কার তো বলেছি সাইন বাই মি বলে দিয়েছে এক্সিবিট হয়ে গেছে
Yes, next.
Mr. Shah, how have you been concerned with the present suit and the documents that have been exhibited in the present suit?
I'm actively involved in this transaction from beginning because that time I was a part of the international sales team. International sales.
Can't hear you. And slowly so that he can take it off. Okay, sorry.
Chief वापस ले लो. Chief वापस.
That time I was part of repeat.
From the beginning, that time I was the part of the international sales team.
আর কি বলবে আচ্ছা ঠিক আছে আর আর
চারটে ডকুমেন্ট আছে শুধু ডকুমেন্ট ডিসক্লোজ করা না টেন্ডার করা নরমালি ওই যেগুলোতেই মার্ক হচ্ছে
My lord, there were 4 more documents. Basically,
not new documents.
No, not new documents. These have been disclosed, but because of the 65B certificate, they couldn't be exhibited at one time. That's what I intend to do with him. Those documents have however not come today. Can it fix it? We'll do it. এটা করেছি তো আজকে তোমার কি এফেক্টিভ হয়ে গেছে
এই যে চারটে পারচেজ অর্ডার জেবিডিবি পার্ট
only for purchase orders and the 65Bs. Nothing much remains. They can start on the next day because the documents are all known to them. There's nothing new which is coming up.
Let them complete their examination, my lord. We have to take.
They are not having the document.
That the originals have unfortunately not come.
Computer, I left to know what is the original.
And the 65B certificate, unless that is there,
cannot doubt.
That is the only problem. No, it's no longer known as 65B.
Number 2 is present. And during his examination, one document is marked as exhibit OO. Counsel for the printing press accordingly chief is deferred. Accordingly, chief is deferred. Let the matter appear on
Very well. He will continue as per.
27th October at 3 p.m.
My lord is fixing it on
27th October 3 p.m.
27th October.
At 3 p.m.
Yes. October 27th.
27th October.
20 years. My lord.
Next.
3 p.m. Witnesses ঠিক আছে তো দিন ছেড়ে জানেন
27th October আপনি আছেন 27th
এক মিনিট 27th October ঠিক আছে তো মনে হয় বলে হবে না 27th October 3 p.m.
Your motion, item number 8.
Item number 8, I appear on behalf of the defendants. I mean, led by Mr. Pratik Mojumdar. Today was our date to give a reply. Mr. Ray had completed his submissions on the last occasion. I am praying that the matter be taken up on Tuesday or any day thereafter, because Mr. Mojumdar is on his legs before the Honorable Division Bench before court number 11. Actually, the matter might continue. I'm not praying for a pass-over. I'm praying for that the matter be adjourned for the day and that be taken up on Tuesday or any day thereafter, Lordship.
As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear on 26th August. Yes, next.
Great.
Well, I was addressing your lordship on that section 5.8 application. My lord, on the last occasion, I was taking your lordship through that those emails, my lord, to establish that there is a relationship between that Netherlands company, the Indian company, Flint Netherlands, Flint India, and my lord, the defendant, to establish that chain. My lord, for convenience, I have prepared in the form of a table, my lord, and I have, my lord, in the last column, given a description of the emails that will be, my lord, to just to save time, my lord. My lord, for the time being, need not look into the reply. Just see this chart, my lord.
Yes.
My lord, this was your lordship's copy, my lord. My lord kindly marks this, my lord. This is stitched. I'm just, my lord, placing the first, my lord, note at the top. Flint Group Netherlands is a part of the Flint Group. Distribution agreement dated 26 September 19 was signed between Flint Group Netherlands and Sujoy Lodha. Sujoy Lodha is, my lord, the defendant. Website of the Flint Group reveals that its India office is in Kolkata and managed by the plaintiff, which is Flint Group India Private Limited. Amar Sen is the Deputy General Manager of Flint Group of Kolkata office. Sachin Kumar is Chief Financial Officer of Flint India. Upal Rai is the Managing Director of Flint India. My lord, lordship will find these three names in the emails which I have referred in the table below. Now, my lord, from these tables or these chain of emails, I only, my lord, intend to show the relationship, which is an admitted position, where the plaintiff, that he was acting as an affiliate of Flint Netherlands, and whatever transaction, or he was involved in the transaction, even in the formation of the distributorship agreement subsequently in 2019, and the distributorship agreement which contains the arbitration clause says that it will have effect from 2015. So whatever transaction the plaintiff did was as an affiliate of Flint Netherlands, and therefore as the non-signatory, being, my lord, the plaintiff here, because he says he is a non-signatory to an arbitration agreement, he is bound under the distributorship agreement. This is the argument I wish to advance. My lord, the first email is, my lord, 20th of April 2020.
Yes.
This, my lord, Flint Netherlands, last column kindly sees, Flint Netherlands has concluded 5 contracts with dealers in Asia Pacific region that were described before October 19. But no contracts for the same were received by Flint Netherlands. Then, my lord, the second email, which is again at, my lord, 21st April 2020, from Flint Netherlands to Flint India, SAS, that is the defendant, was recognized as India distributor. It is mentioned that the agreement with SAS was not signed. Third email is, my lord, from Flint Netherlands to Sachin Kumar, Flint India. Contract for SAS sent to Amar Sen on 27 September 19. However, SAS has not digitally signed the document. Kindly, my lord, takes a note that Flint Netherlands and Flint India is corresponding with regard to a formation of a contract of the, my lord, Flint Netherlands with the defendant. Then the fourth email, which is 21st April 2020 at 22:24 hours, Sachin Kumar, Flint India, writing to Amar Sen, Flint India. Internal communication in the Flint group stating SAS should sign the agreement. Next, Flint India writing to defendant Sujoy Lodha, requesting that the defendant signs the distributorship agreement with Flint Netherlands. Well, this is a clincher according to me, because you are in the capacity of an affiliate, you are writing to the defendant saying that please enter into the distributorship agreement, sign it, which you are going to enter with Flint, Netherlands.
Flint India requires the defendant to sign the distribution agreement. Okay.
Flint India requesting defendant to sign the distributor agreement with Flint, Netherlands. And I'll show from the distributor agreement that Flint India is described as an affiliate of Flint, Netherlands.
Okay.
My lord, the next email is from my lord Flint India to Flint, Netherlands. Internal communication in the Flint group, sharing details of the defendant and his email for his digital signature.
Correct.
Kindly turns the page, my lord. Sujoy Lodha, my lord, defendant, writing to Flint India. Mail to Flint India inquiring about the possibility of certain changes could be made to the distributorship agreement.
Yes.
Then, my lord, next, again from Flint India to defendant, mail to the SAS where Flint India acknowledges that all distributor agreements are being signed with Flint, Netherlands. Flint India is run by Flint, Netherlands. My lord, these are, my lord, taken from the emails. Lordship can, my lord, I have given the page numbers in the first column. Last email, this is, my lord, the contract. SAS, which is defendant, writing to, my lord, Flint India. SAS digitally signs the contract through DocuSign and sends it over to Flint India. Now, this document kindly takes, my lord, from the, my lord, petition, page 140. My lord, of GA, this is GA4, 140.
Yes.
Lordship has 140. My lord, kindly sees how the parties have been described. Distributor agreement between Flint Group Print Supply Platform BV so and so Netherlands, hereinafter referred to as Flint, Netherlands, and SAS India, hereinafter referred to as distributor. SAS India is my client, my lord, defendant.
Print Group Print Supply Platform BV Station Print.
And at the bottom, my lord, it's written hereinafter referred to as Flint, Netherlands. And then my client and SAS India referred to as distributor. So this is how the parties are described.
Yes.
Now, my lord, kindly comes to page 142. One 1.4.
Yes.
Distributor shall have a non-exclusive right to distribute the products in the contractual territory, that is Flint, Netherlands, may appoint other sales organizations, in particular commercial agent or distributor for the products in the contractual territory. In addition, Flint, Netherlands or its affiliates as defined below, Flint, Netherlands and its affiliates hereinafter collectively referred to as Flint, may conclude transactions in respect to the products directly with key customers or customers who belong to an internationally operating group within the contractual territory. So either it is Flint, Netherlands or its affiliate who can do this contract.
No, distributors have a non-existing right of the distribute product in the contractual territory. Flint, Netherlands may appoint other sales organization, particularly commercial product territory, in addition to Flint or affiliates.
Now, affiliate is defined, just my lord skips 6-7 lines. In bold, lordship will find an affiliate, sentence starting with an affiliate shall be understood as an entity having the direct or indirect control over Flint, Netherlands, or being under the direct or indirect control of Flint, Netherlands, or being under the direct or indirect control of a controlling affiliate. These are the three definitions of affiliate. I rely upon II, my lord.
Being under the direct control of
Flint, Netherlands. Now, my lord, kindly comes to page 143. Article 3, 3.1 is relevant.
Yes.
Distributor shall buy the products. Distributor is my client.
Yes.
Shall buy the products in its own name and for its own account from the respective selling Flint affiliate, hereinafter referred to as Flint selling affiliate, and resell them. I say, my lord, plaintiff acted as, my lord, a Flint selling affiliate under Flint, Netherlands. Okay. And that is why plaintiff was concerned with regard to the distributorship agreement, which according to Flint, Netherlands was not signed. he was referring to that email where 5 contracts with 5 distributors not signed, and this chain ultimately shows that Flint India was acting on behalf of Flint Netherlands to ensure that I actually sign the contract and give it to them. Then my lord kindly comes to page, after my lord 3.1, kindly comes to page 147, article 7.
Yes.
Article 7, 7.1. The products shall be sold to distributor on the basis of the orders placed by the distributor, that is my client, and Flint selling affiliate, that is the plaintiff's order confirmation, unless otherwise provided for in this agreement. Current prevailing terms and conditions of sale agreed between Flint selling agreement affiliate and the distributor, as well as the general terms and conditions of sale of Flint selling affiliate as modified from time to time, shall apply to the purchase agreements concluded under this agreement. So my lord, Flint selling agreement has the liberty under the distributorship agreement to my lord issue orders on the distributor, which is my client. Now my lord, the clincher according to me, page 148, article 10.1.
Yes.
This agreement shall come into effect, kindly marks this, retroactively on September 6, 2015. And my lord, the claim in the suit, which the plaintiff maintains, arise out of, they describe one purchase order of 2022. So my lord, if the distributorship agreement says that it predates and takes effect retroactively from September 2015, any contract which the plaintiff had entered with my client, the defendant, as the Flint, it was in the capacity of a Flint selling affiliate, and that is what is regularized or recognized in the distributorship agreement. So basically, he is trying to sue and recover money. Plaintiff is trying to sue and recover money under contracts which the plaintiff had entered into pursuant to this distributorship agreement, and it was signed in 2019, my lord. I'll show the date from the emails. 2 dates are very relevant. I'll show that also. They were well aware that it is, my lord, 2019. Why is this, my lord, suit instituted? Lordship may have this query for me. Then why did the plaintiff avoid this agreement and institute the suit? Because, my lord, it says we have to go to Amsterdam for an arbitration. It's costly, my lord.
I don't think so.
Well, there's no other reason, my lord, for them to avoid the arbitration agreement.
No, kindly, where is the plaint?
My lord, kindly, it's annexed to the, my lord, application. Kindly comes to page 13 of my application and sees, my lord, how they have framed the cause of action.
That's what I'm asking. Where is the cause of action?
My lord, page 14, lordship will see, page 15, para 3 and 4. Page 15, para 3 and 4.
Parties entered.
I'll read it for your lordship, my lord. Pursuant thereto, parties entered into negotiations and discussions during which terms and conditions for supply and or delivery of goods and payment were duly agreed upon. It was agreed that defendant shall place verbal as well as written purchase orders on the plaintiff, and upon receipt thereof, plaintiff shall cause delivery of the ordered goods from the plaintiff's godown at Srijan such and such to defendant's godown at such and such. It was further agreed upon by and between the parties that immediately upon delivery of the goods, plaintiff shall raise appropriate invoices on the defendant, and upon such invoices being raised, defendant shall make payment against the same within a period of 90 days from the date of each invoices. In default such payment, the outstanding amount would carry an interest of 18% per annum. Aforesaid discussions and negotiations took place, and agreement was concluded at the office of the defendant. Apropos such agreement between the parties, defendant placed orders on the plaintiff from time to time on and from March 22. So, my lord, lordship has to now see, my lord, from the distributorship agreement, or my endeavor is to, my lord, persuade your lordship from the distributorship agreement. Lordship will find that plaintiff is actually acting in the capacity of Flint selling affiliate. If the agreement, distributorship agreement, is with effect from 2015, and you say in your plaint that whatever contract you had entered into with the defendant is of March 2022, because PO is of March 2022, then you are definitely bound. And as Flint India, you are definitely bound under the distributorship agreement. You cannot claim that because you are a non-signatory to the agreement, you can bypass the arbitration mechanism that is envisaged under the clause, the arbitration agreement in that distributorship agreement. I am trying to, my lord, draw a nexus between
Who is
the
party to the agreement?
It's Flint, Netherlands, and the defendant.
Defendant. Then how it is binding?
My lord, it is by operation of law. My lord, the language used in my lord.
Yesterday judgment you have gone through the Supreme Court. Non-signatory cannot be a party to the arbitration.
I was carrying Cox and Kings, my lord, which says, my lord.
No, that's just yesterday. I think yesterday, day before yesterday. Yes,
I don't know why he is smiling. I think he has gone through that judgment.
Justice Narasimha's judgment. It came in live now.
Later judgment.
I'll consider that, my lord.
Considered it.
I'll consider that.
Considered it. It is because it is categorically held non-signatory party cannot be a party to the arbitration.
But then, my lord, in that case,
we are holding the Cox and King.
Yes.
And then just a month before I pass an order, you can go to the arbitrator. The third party is interest, but you can go to the arbitrator. But
and I was also trying to persuade your lordship to hold that here. But then we have to, I'll definitely consider that under what circumstances that, my lord, observations have been made.
No,
because that will also be binding on your lordship, I understand.
Gone through that also. I will also go through. Please consider
I
that.
was carrying Cox and Kings. I was carrying a Delhi High Court very recent judgment.
That is correct. If it a third party interest is there, then it can be.
Yes.
But and that will be decided by the arbitrator whether he can be joined or not.
Otherwise, my lord, it would be like avoiding the arbitration agreement. It's very easy for these parties to avoid an arbitration agreement and institute an action. Though you are a Flint selling agent, Flint selling affiliate, you avoid that relationship and you sue me directly.
And now Section 8 and Section 11, the Supreme Court, I don't know.
Too many judgments coming at short intervals, and my lord, it's
that is the problem.
At variance from each other.
The problem. Sometimes if it is you find any link, you can refer it.
I was trying to fit in my case.
Sometimes it find that if you unless it is a signatory, you cannot.
Yes. Initially, that was, my lord, the law. Later, it was developed that non-signatories, group of companies doctrine was, my lord, brought in, and then, my lord, non-signatories were.
Even in the bank, two parties, and bank is a third party with regard to the performance. What we saw in the and bank invoking the guarantee. So where he will go? If you come to the Section 9, if the Section 9 give the stay, then you have to go to the arbitration. The arbitrator says bank is not a party.
But claiming, my lord, subject to being corrected, claiming a relief against a third party to an arbitration agreement is possibly, my lord, permissible because the language used in Section 9 is that only a party who is applying.
That's with the third party. The bank guarantee is there. Third party, bank is invoking. So you have to go to the Section 9. If you got the stay order, Section 9 stay order not till the disposal.
Banks are coming with appeals. Banks are coming with appeals because they are aggrieved by those orders, though they are not parties to the arbitration agreement.
The problem. And in the Section 9, we have a only limited period, and it is to be decided. The arbitrator will say he is not a party to the agreement. What will do? So where the remedy is? That all the things are there. Okay, you consider that also.
I'll consider them. My lord, kindly keeps it Tuesday, my lord.
Okay. Learned counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 19th under the same matter.
The interim order is still there in till 19th.
Okay.
So we'll come back on 19th or
Come on 19th. Come on 19th.
Okay.
I'll give a copy of that chart which I handed up today to Mr. Dashgupta. তুমি আছো?